love to smell and appreciate. I'm just never smoked them. I went golfing one time. Well, I had a friend of mine, Greek gentleman. We got started pretty soon. He invited me over. I walked into his house. We're in the basement. He has a walk-in humidor. So I walked in, and he's got cigars wall to wall, ceiling to floor. I said, Johnny, how much you got in cigars? He said, about 50 grand in cigars. He said, you ever need a cigar for an outing or something? I mean, no. So about a week later, I was going to a golf outing. I said, yeah, I'll take a few. So he says, I'll leave them in my mailbox, pick them up the next morning, take them to the golf outing, which I did. They all smoked them. They were VSB vintage was the brand name. I don't know anything about them. So the one buddy, they all loved them. The one guy next day goes, now this is 15 years ago. I used to buy some more. We enjoyed them so much. 15 years ago, they were $25 for one. And that's why he enjoyed it so much. And that's an expensive cigar, David, even today. All right, we'll get started here. Again, if you intend to speak tonight, please come up to the lectern and sign in. And then Charlie will swear everyone in here shortly that will speak. So Georgetown-Scott County Planning Commission agenda, December 9, 2021. It is 6 p.m. and we're going to start the meeting. Go a little out of order here. We recently had an attorney here pass away, Bruce Lankford, and we wanted to honor him with a proclamation, so I'll read it. Georgetown-Scott County Planning and Zoning Commission Resolution Number 21-02. Resolution related to R. Bruce Lankford, whereas it is necessary upon the passing of R. Bruce Lankford, attorney at law for the Georgetown-Scott County Planning Commission, to memorialize upon the record the impact of Bruce's many years representing Scott County properties throughout the planning and zoning process. And whereas Bruce's professionalism, courtesy, equanimity, gosh, that's a hard one. It's too big of words, Charlie.
Equanimity.
Equanimity, thank you, with which he approached the commission, its staff, its members, and the Georgetown-Scott County community, whether supporters or opponents, have contributed greatly to the standard this commission strives to maintain and expect of every participant. Now, therefore, be it resolved by the Georgetown-Scott County Planning Commission that R. Bruce Lankford, long-standing attorney practicing before our Planning Commission, be recognized for exemplary service to his many clients and to the community at large. His contribution to both is beyond measure. His loss is keenly felt. The foregoing resolution was approved by unanimous vote upon motion by and seconded at the Commission's regular meeting December 9th, 2021. So I just need a motion to pass this resolution.
So moved.
So moved by Mr. Mifflin, second by Dan Smith. All in favor say aye. Aye. Thank you. And then we'll present this to his son, John. Thank you all.
Yeah.
And so we'll move on. Commission business, I need the approval of the November invoices. So if you had a moment to look at the invoices. If you do have a cell phone, please mute it. That's what I'm doing myself, so we don't get too disturbed throughout the meeting. I need a motion to approve the November invoices.
I move.
Got a motion? Okay. Try to follow this, sorry. Got a motion by Mr. Stone, a second by Mrs. Singer. All in favor say aye. Aye. Anybody opposed? Motion carries. Approval of the November 10th, 2021 minutes. I need a motion.
Motion.
Motion by Mr. Garrett.
Second.
Second by Mr. Stone. All in favor say aye. Aye. Motion carries. Approval of the December agenda. You all have a copy and have had a copy for a while, so I need a motion for the December agenda.
Are there any changes to it?
Do we have any changes? Okay.
I'll make a motion.
Got a motion by Mrs. Singer. Second by Mr. Vest. All in favor say aye. Aye. Opposed? Motion carries. Items for postponement and withdrawal. So I'll go through them because there's several. So when you hear these, again, these will be either postponed to next month, and we've even got one that's withdrawn. So for postponement or withdrawal, we've got ZMA 2021-37. It's 1058 Paris Pike rezoning. That one's been postponed, so if you're here for that, we won't be hearing that tonight. It's postponed till next month. The other one on there is PDP 2021-44, the Penn Alley Townhomes. If you're here for the Penn Alley Townhomes, those are postponed till next month. ZMA 2021-46, the 11, I'm sorry, that's a public hearing. ZMA-2021-47, the Cynthiana Road, that's also withdrawn. And then, did I miss any? Oh, Regal Springs, thanks. PDP-2021-45, the Regal Springs, that one's postponed. So if you're here for any of those four, they will not be heard tonight. Those will be heard probably next month, if they're not postponed next month. All right, moving on. Anything else, Joe?
No, I mean, we had discussed, well, no.
Well, we'll to consent agenda. So we had one we thought was consent eligible, but because there's several changes, at this point, we have nothing that's consent eligible at this moment. So moving into old business under item number 2, we'll start with FSP-2021-25, the Fairfield Farm subdivision. Final subdivision plat to subdivide an existing lot into 3 lots in Fairfield Farm subdivision located at 3684 Frankfurt Road.
You want to swear everybody?
Yes, if you're going to speak tonight, please stand, and Charlie's going to swear you in.
Is there another page somewhere? We've got 3 names and a lot more than that standing up. I like that 3 names, but I didn't think it was going to last. Do you all swear or affirm the statement you're to make tonight to be the truth to the best of your information and belief? Thank you.
Thank you. Joe, you've got the floor.
Yes. This is a request to approve a subdivision plat in Fairfield Farms subdivision. You reviewed this in August. It would be a fairly straightforward request. It's a 21-acre parcel, slightly larger than 21 acres, that was approved as the first lot on the right as you go into Fairfield Farms as part of the original subdivision. They are requesting to re-subdivide that into 3 tracts. This is the location on the front. It's actually on both sides of the road as you enter. So they're coming back now to request to re-subdivide it. It meets our minimum lot size in the A1. It's the width, the setbacks are all meet our requirements. I guess the question at this point, or the main issue out there is the road has deteriorated. So it was built to our standards at the time in 2005. Since then, it's deteriorated as the houses were constructed. I think it had been patched or repaired a couple times in the past. So the question now is, do we approve the subdivision of new lots that will access a road that's deteriorated? So I guess the reasoning in the planning staff's recommendation of approval is that 2 additional lots on the road will help pay for the, bringing it back to county standards, since the road will have to be approved to county standards in order to be accepted in the public road system. So that was our reasoning. It meets all our standards for 5-acre lots in the A1. It was, I think, anticipated to be subdivided. Sorry, I'm trying to advance to the plat itself. There we go. Okay, so this is the general layout of the plat that they're asking for approval on. So they want to, the lot has a house and a garage and a barn on it. They want to keep those on one lot and then split 2 more accessing Fairfield Farm Road. So the reasoning for our recommendation for approval is that it meets our minimum requirements. By adding these 2 additional lots, it'll help pay for bringing the road up to standards. If you know, if there can't be an agreement on how that road will be brought up to county standards, I think they did an estimate. They know what it's going to cost. You know, you may consider not approving these because it may exacerbate the problem. But at this point, we were hoping that, you know, an agreement could be worked out with the existing lot owners and the original developers who own this parcel 10, this remainder. So I didn't update the staff report with any other information, so that's all we had. We are recommending approval with the, I think, 5 conditions, 4 or 5 conditions?
5.
5 conditions. Number 4 being that these lots be included in the HOA and pay their proportional share of the future road maintenance. And there is a large karst area on these 2 lots, in that those areas will be unbuildable until, you know, until or unless they do a geotechnical study and shows that they can be built in those areas. Otherwise, the plat will indicate those are unbuildable areas.
Thank you, Joe. Any questions for Mr. Kane?
I've got a question, not necessarily to Joe, but maybe to Mr. Sims. Last month, they had, like you said, it had been brought before us in August and continued to last month, and before the meeting ever started, Mr. Sims asked the homeowners and the owners to come out in the hall, and then came back in here and said they were postponing it another month, waited to this month. So was anything accomplished?
I think let's do this. We'll bring the applicant up Mr. Sims, if you're representing the applicant.
I mean, if all we're gonna hear is you need to approve it by the owners and we don't need to approve it by the homeowners association, if nothing was accomplished, I don't see any need to hear it.
I think I found out how much the estimate was on fixing the road. It allowed me to contact Hinkle and see if that estimate was still accurate and viable. And I learned that the passage of time and it's gone up a little bit. The cost of asphalt has gone up from like $804 to $824 per unit ton, but so the amount that the 112,000 plus figure that we had received in July is now a bit higher, but it's not exorbitantly higher. My client, the Guthries, we made a representation to the neighbors that basically that we would be glad to, as owners of lots, of the 2 new lots that would be added, we would be glad to pay our 1/11. The existing homeowners association declaration of covenants and restriction exempted the developer from assessments on the 1 through 9, but since we're adding these two new lots, they're willing to pay their portion of the 2/11ths to help bring the road up to standard, so it can be submitted to the county for consideration as acceptance as a public road. Not only are we will do that, but also these 2 lots will be sold subject to all the other declaration of covenants and restrictions. So the owners of 10C and 10D would have the same requirements in terms of building materials, the size of the houses. I would basically do an amendment or a supplement to the existing declaration of covenants and restrictions to make these 2 lots applicable in all ways, including the assessments to bring the road up to repair and the assessments in the future if a homeowner association is formally formed. And it was my understanding from talking to the neighbors last month that they are in the process of having somebody form a formal homeowners association. These lots will be subject to the same requirements that they have to contribute if it's a monthly or an annual assessment, and that they would also, that they're willing to go on the record tonight to say they will pay their portion of the amount of money it takes to repair the road.
What is the new increased cost by Hinkle? you remember?
It's gonna be, it's upwards of 112,000 because of the, it was 112,000 and some change prior to, I guess, the inflation on the cost of asphalt. And that, when you look at that bid closely, there are some, items that may arise in the course of construction that aren't included in that assessment. So I mean, I wouldn't hold me or Hamilton Hinkle to that number because there are some variables in the body of the estimate. I know that it's gone up some just from the cost of asphalt.
What's 1/12 of the total, so in terms of what each homeowner would be responsible?
That's what I was trying to figure out.
Well,
What-
I haven't done
10,000?
that math. Yeah, somewhere in that ballpark is where we would have basically 11 divided by 112, so it's gonna be in the $10,000–11,000 range.
And I guess it
upwards
would
of that
require
little
each
bit.
person to give their portion for it to be done.
Right.
Yeah, if you divide 112,000 by 11, that's 10,200 roughly. But if it goes up, and I know Monday we talked about a $120,000 figure, I'm not sure where we got that from. But if you do 120,000 divided by 11, which is the current 9 residents, plus the 2 additional lots would be 11, that cost would be about 10,900 and some change. So might as well say about 11,000 per lot, which the applicant would be responsible for 2 of those, so they would be responsible for about 22,000, and each resident that's here would be responsible just shy of 11. And that's a rough estimate. Don't hold.
The dispute with the neighbors is that the condition of the road is deteriorated badly at this point, and they feel like they want the developer to pay to repair the road back to the standard, to ask the county to take it over. When you look at the declaration of covenants and restrictions that were in place before the first lot was sold, it was clear that there was an association to be formed, whether it was incorporated or operated without incorporation, that they were to set up an association to create assessments, to have a sinking fund for this sort of thing. It's 15 years since the first lot was sold out there, and the roads have been, obviously, people live there, they've been living there now for close to 15 years. There was a period of time when that was undergoing a lot of heavy construction. The road did meet county standards when it was built. The subdivision plat was signed off on. Engineer Krebs has indicated, I think, to this commission in the August meeting that it did meet county standards when it was built. It does not meet those standards now. I have researched that issue, and there is an Attorney General's opinion. Actually, it came from a request for an opinion from the Attorney General from Scott County on that very issue. What happens when a road was at one point in time in compliance and then it later falls out of compliance? The fact that it was built in compliance, can the county take it over? And the Attorney General's opinion, which of course is not, it's just the Attorney General's opinion, it's not case law, but they said that under the statutes, the county cannot accept it until it's brought into compliance. And that's in compliance at the time it's being requested. So it would appear that even though the road's been in use for some time, and that there was some thought that there was a statute that allowed that to come in, I think the Attorney General's opinion has clearly indicated that it has to be repaired before we can submit it to the county for acceptance.
So I guess if I understand correctly, and correct me if I'm wrong, the road's not going to get repaired if these lots aren't sold, right? It's going to continue to be, is that correct? Well, at least there's no
I can't
plan
answer
in
that. I
place
mean,
to do
they
it.
obviously, there's
no plan
9
to do it
people
with
living
any
out there
funds.
now, and at some point in time, they may want to fix the road.
But at the same point, it might not be fixed
it's
in
not
this
gonna
case,
be
too,
done
because
by
everybody has to divvy up their
I don't
part,
think the
right?
county's generously going to do it, so it's going to come out of somebody's pocket.
Okay. All right.
Any other questions for Mr. Sims? Attorney Sims, sorry. All right, thank you.
Thank you.
Mr. Sims. As far as, does anybody here please want to speak? When you come up to the microphone, state your name and your address for the record, because that's how we dictate minutes.
My name is Richard Dugas, and I live at 111 Fairfield Farms. and I am one of the residents. I'm the owner of lot number 9. And again, several of the members here were not at the August meeting, which was rather contentious, and a lot of facts were brought up, so I don't want to rehash a lot of those, but I might rehash a few of them if you're not familiar with those minutes. And again, I'm personally representing just myself, but if you were not aware, there was a letter filed, signed by all 9 homeowners at that meeting, and nothing has changed. All 9 homeowners are still opposed to this submission as it is submitted. Our standing is, it's our understanding that you can't add additional lots onto a road that doesn't meet the standards. There is not a homeowners association, so there is not a fiscal entity that could enter into a contract with Hamilton Hinkle to fix the road. So your question of, if you approve this, is the road going to get fixed? The road is not going to get fixed. We met for an hour with the developer. There was some conversation. There was a lot of things brought up. There was no decision. There is still miles of difference between the homeowners, and again, not to rehash, what we were promised when we bought a house, that it was going to be accepted into the county. The agreement's already made. The county already agreed to that. So yes, we bought those houses, told by the sellers, by our real estate agents, that the road was going into the county system as soon as we finished closing. 15 years later, it is still not. It's not meets the standards. Mr. Krebs, Mr. Brandenburg were out. They inspected it. They prepared the county prepared the minimum standards. That's what the quote from Hamilton Hinkle is based off from. I'm an architect. I work in the construction industry, and costs are going up daily on construction. So the $112,000 has been. By next summer, this could be $150,000 or more. So essentially, if this is approved, the only one that gets enriched by this is the applicant, who is going to sell 2 additional lots for the current going rate, make a pretty good parcel of money selling 2 lots. The homeowners that are out there now are not going to be enriched. In fact, we all feel that we're going to be, the character of our neighborhood is going to change, because now you're jamming 2 more houses right in front of the subdivision that are going to, because of the karst area, are going to have to be built right up on the fence, right next to the road. That's not what we bought. So again, had these lots been added in 2005 to 2007 when the road met the county standard and before the people were bought the lots, no problem. That's not where we're at today. The applicant is asking you to change the existing approved standards. The road does not meet county standards. There is not an agreement. We do not see any path forward unless the county wants to step up and come up with the money to fix it. We do not see a path forward where there's going to be an agreement. Like I said, the developer and the group of homeowners, because there is no homeowners association. And also from a legal standpoint, let's get back to that. Again, I'm not a lawyer. So my understanding after contacting Planning Commission and PVA, the road is currently an undeeded right-of-way that is owned by Hobson Properties, the developer. So as a private citizen, yes, that at some point as a homeowner, I'm supposed to join this homeowner association. Can I legally even go out and do something to somebody else's property? I'm not sure. I'm not asking that question, but that's a question that you all have to do, because there is not a legal entity. I've worked for developers before, and typically the way this works, and again, to rehash, again, not anything against the developer, but typically the developer, Ball Homes, who I work for, when they go in, they set up a subdivision, one of the first things they do is they file with the Secretary of State, they form that homeowners association, they appoint their lawyer, 2 members of the developer, they create a board, they set all the bylaws, and then they deed the right-of-way to the homeowners association, and then at some point, when they meet whatever criteria is outlined in the homeowners association deed restrictions, they turn around, they deed the land over, they send a registered letter to all the homeowners and say, it's your baby now. I am not aware, I've lived there, I was the first house in there, I have never received a registered letter saying, this is the homeowner association, here's your baby, you're now responsible for it. So again, I'm not a lawyer, that's the way multiple times I've seen that done typically, because a lot of times developers do that and they actually walk away because they formed an LLC, and then they just let the LLC end up with all the problems that come from residual development land. So, I mean, I think that's, is there any questions regarding that? Anybody have any questions about, again, there is no homeowner association. You do have a letter that was signed by all 9 existing homeowners. We did try to negotiate in good faith, but again, I think we're too far apart on what we feel is an equitable solution. And again, we would love to welcome the county into the conversation, but, you know, like you said, I mean, whether it be 11,000, 12,000, or whatever that dollar is, you know, there's no entity, there is no homeowner association, so you can't place special assessments on anybody's property. So where we get from here today, so I think based on, I'm concerned that if you do approve this, that you're setting a dangerous precedent by saying, well, the road met it way back then, so what's the next person that's going to come back and say, oh, well, you know, hey, I had this property over here that back in 2000, is it 2007? Is that good enough it met a precedence, or is it 2000 or 1995, whatever? I mean, you're doing revisionist history here. My understanding of your charge is, does it meet what's in the Code of Ordinances today, which is you're adding lots to an undeeded right-of-way, and you can't add lots to an undeeded right-of-way when the road doesn't meet the standard. And as of today, the road does not meet the standard, and it's at least $125,000 short of that standard. So, appreciate your time.
Thank you, Mr. Dugas.
Hey, Mr. Dugas, I've got a question for you before you leave. You gave us 2 reasons for not approving this. One of them was the houses would be built too close to the road.
They're going to meet the standard. I mean, I understand the setbacks are there.
Okay, so, and you had said if they were sold back when you bought yours, it wouldn't have been a problem. So that's really not a problem just because they're going to be built a little closer to the road than you are. Because if they had been sold 10 years ago, they would have been built in the same place. Is that correct?
Meaning that the character of the subdivision, when you bought it, those lots did not exist. When I signed my contract and was given my plat, right there was not going to be a house sitting right in front of me, where lot 10C, if you back up,
Gotcha.
is going to be built. I'm going to be looking out my front door at their back door. Okay?
Okay.
So that's what I meant by and on lot number 1, again, the same thing. The owners of lot number 1 who bought this, they bought the character of looking over a horse farm, and now you're going to turn around and put 2 houses right in front of their house. So that's where I meant that there is actually a detriment to several of the homeowners directly by approving that.
If we don't approve it, and the Guthries just sit on this property for a number of years, what's going to happen to that road?
It is potentially going to continue to deteriorate.
And who's going to fix it then?
Most of the homeowners out there, we own 4-wheel drives, and if it's got to go back to gravel, it's probably going to end up going back to gravel.
Okay.
But, I mean, again, we were told when we bought the lots, the road was going to go into the county. I have been having conversations, and again, you know, this was what part of the testimony in August. I've had conversations with county officials, Mr. Brandenburg, since 2007 when I bought my lot. When are you going to take it over? At the time, the county standard was you had to have 75% or 60%, Mr. Krebs, a certain percent of lots. What ended up happening is myself on lot 9, lot 7, and I believe it's lot 3. We built within the first year, and then nobody else built for like 7 or 8 years. Meanwhile, garbage trucks, everything else going up and down there. And then lot 8 built. It's only been within the last 36 months that the last 4 houses have been built. So that's where you end up, it never met the standard to go into the county system based on this percentage or whatever.
Right. 50%.
50% or
Until it
whatever.
had already degraded to.
So, and during that time frame, the road continued to degrade over.
And we've also now increased our standards since 15
Correct.
years ago.
So, that's where, and again, I know we're not the only subdivision there, but, we're in that catch-22, but
So to Mr. Mifflin's point, if we don't approve it tonight, the road continues to disintegrate. Could there not be an opportunity to come to terms and go divide it by 11 ways and let's just get it done and move on?
Well-
Because that's your only really alternative.
again, not to rehash the points,
Yeah,
is
I hear you.
we felt that the homeowners that are out there felt that the road, while it appears to have met the standards, was,
Right.
substandardly constructed.
And that's why we increased the standards, and that was prior to my time as a
And
commissioner.
had
Charlie was
failed-
probably the only one who was here when we increased the
Probably the
standard.
only one.
Maybe
What are you
Ben.
trying to say, Mr. Chairman?
You're a couple years older than me,
So-
Mr.
I was
Perkins.
here before the standards were
So,
developed in the
The,
first.
to Mr. Mifflin, when we bought the house in 2007, it looked like a good road, didn't look like there was a problem. Sure. It quickly became a problem, and again, we reached out, hey, when is the county gonna take this over? Oh, we're not gonna take it over, we're not gonna take it over. Continues to fail, continues to fail, continues to fail. And then we also talked about, during all those years, while yes, the HOA or the deed restrictions say one thing, during that time frame, up until you meet that 50% requirement, it's the developer's baby, correct? Or is it not? That's, so,
I guess you didn't have they did not have a contractual obligation, according to your contract, to keep it up to a minimum standard until that point, or there was no contractual obligation?
Probably not.
I mean, from the contract where you bought your lot to build the house.
no, I mean, when I bought my house, I was told this is gonna, within the next 24 months, this is gonna go into the county road system. That was in 2007. And so within 24 months, I was, hey, JR, when are you taking this over? And on until, hey, we can't take it over.
Okay. Thank you, Mr. Dugas. Anyone else like to speak? Attorney Sims, we'll have you up right after the attorney. Thank you.
Thank you, Mr. Chairman. If I could, just by way of response, the declaration of covenants and restrictions that were placed on record in October of 2004 before any home was sold says very clearly that the homeowners, the Fairfield Farms Homeowners Association shall become effective as an association. It was never intended to go through the incorporation process and the process that he described that Ball uses and other people uses. I have, in the past, in my time in town, people have come to me that have been on a road where they were supposed to have shared commitment to a road, and they've asked me to put it together years after it started. So it's not a foregone conclusion that every development has an incorporated homeowners association. And this one says, it shall become effective as an association and assume the responsibility for operation, maintenance, and repair of Fairfield Farm Road when the final layer of paving has been installed. And then in the next paragraph, it talks about the purpose of the homeowners association. So long as no municipal government agency has taken over the operation, maintenance, and repair of Fairfield Road, the purpose of that shall include the maintenance and repair of the road. The fact that these people didn't do it on their own, or the fact that it didn't get done. I didn't prepare the homeowners association documents, didn't represent the Guthries at that time. I can't speak to why it started the way it is or how it got started, but it's clear that when they accepted a deed to this property, they became a member, they were to become a member of an association that had as an obligation the shared commitment for the upkeep and maintenance of this road until a government agency took it over. The fact that a sales representative may have told him it was going to be done, I think it was always intended that that would happen. But it didn't happen, and the responsibility until that happened fell on the homeowners association. The Guthries are saying, we'll that they could sit back and sell lot 10 as it is and just let everything continue, but they're willing to, let's divide these two lots. We'll assume 2/11 of the cost of the upkeep, the repair of the road, so we can ask the county to take it over, and then maybe the burden on the homeowners association from that point forward will just be for, the entryway, or if there's a sign and flowers around the entryway, they'd have a minor commitment to, but there's going to be an expenditure to get the road to a standard where the county will accept it. My clients are prepared to pay 2/11 of that number, and hopefully everybody can kick in and we can get the road back to county standards to get them to accept it.
Contingent
Thank you.
upon the sale of these lots.
Yes.
Thank you, Mr. Sims. Ma'am, if you would like to come on up.
I'm Denny Hamilton. I've been a realtor in Scott County for 40 years. And I feel like this is truly an unfortunate set of circumstances for both homeowners and the developers. Unfortunately, I feel like Mr. Dugas, I'm sorry, probably bought in good faith, thank you. But I'm certain that he was given a set of the restrictions, as most realtors in Scott County would provide restrictions that clearly stated that the homeowners would share the responsibility of the road. Unfortunately, the road was not able to be offered or requested by the county because not enough of the lots were sold. We went through a recession, and unfortunately, the Guthries had invested a lot of money in a road and a subdivision that they had a lot of carrying charges for a number of years waiting for the recovery of the real estate market. It's a beautiful subdivision, and, for all practical purposes, you would think that their property values have been diminished by the condition of the road, and it does need work, and there's no question. But people are paying today's market and fair market for those houses the same as they would if the road were in good condition. I think that it would be unfair and unjust not to consider the Guthrie's request, because it was never the intent for that to stay green space. As Mr. Dugas said, he would prefer to look at the green space across the street instead of someone else's house. The Guthries, in my opinion, probably didn't sell that because they lived directly across the street and were fortunate enough to own the property to protect their view. It's not what they want to do now, and I think that it would be a shame to penalize them at this state, because we had a downturn in the real estate market and that there was never a homeowners association officially formed, but every homeowner in that subdivision at some point was informed that they were responsible for the upkeep of the road until such time that it was taken over by the county. And they had every right as a homeowners association to join forces and request the county take over. It's not necessarily a total responsibility of a developer in all circumstances.
Thank you,
all.
Mrs. Hamilton. Anyone else like to speak? Go ahead, Mr. Dugas.
Just one short rebuttal, and that is ultimately, again, remind the commission of the planning and zoning's recommendation, which is if their concern is the road's not going to get fixed, that they would not recommend you approve this. And I'm letting you know, and you have a written letter from August that was submitted from the 9 homeowners that said the road's not going to get fixed. You got it in writing, signed by all 9 homeowners. So make your decision based on that. You have all the information.
Thank you. Mr. Kane, this meets all requirements of the Planning and Zoning Commission,
Except for the road.
All
except for
lot-
the road.
Yeah, all the lot requirements except for the road, yeah.
So, I mean, it is, I think, too, and it may have been Mrs. Hamilton, it is a little of the perfect storm. You know, the road was up to standard 15 years ago. You know, the lots weren't sold 50% or more, so the road sat there and couldn't be dedicated. So at that point, it wasn't Mr. Guthrie's or the developer, I think if he were the developer at the time, responsibility to upkeep that road or get it dedicated. He couldn't get it dedicated because it didn't meet the 50% homes sold, like you said, Mr. Dugas. Last lots that were built on last 36 months. So I think you got, you know, it's a little of a perfect storm where you either enter into an agreement with them to get the road done at the cost, or y'all drive 4-wheel drives until forever. Because if their chance of them committing the roughly $2,000 to get it fixed is today, once they sell the lots, now you're just gonna those 2 new lots are gonna join your HOA if you eventually form that, which it hasn't been formed yet? It has not. Okay. So now Mr. Guthrie's not gonna own those lots. You're still gonna have 11 homeowners that are gonna have a road that continues to be deteriorating. Somebody's gonna have to man up and kick the money in, whether it's 12,000 or 10,000 or 11,000 today. And to your point, costs continue to go up. Guess what? 5 years from now, instead of 11, it might be 20.
But ultimately, the current ordinance is you can't have lots if it doesn't meet standards.
Charlie, I was gonna defer to my attorney because I'm not an attorney.
Yeah, we've been hearing too much law, and some of it's just simply not correct. There is nothing that says these lots can't be added, but there is a distinction that hadn't been touched on yet. You can have a gravel driveway on 3 lots, correct? So we've already got 9. We can't add 2 to that. What we can do, though, is approve these because they do satisfy our requirements. And as we talk about all the time, when they meet our requirements, we've got to say yes. But the crook in this one is that it's only a maximum of 3 on a less than county standard road. So a condition would need to be added that, yes, they get these lots, and they bring that county standard up for those 2 lots. And unfortunately, the folks that are already there just get, well, they just continue to drive 4-wheel drives, I guess. But that way, the new lots are not impinging upon them. They're not forcing their requirements from 14 years ago on the 2 new lots.
Now, when you say 2 lots, are we, and I'm looking at the map, and Joe helped me out here, looks like 391 feet. They would then have to bring that 391 feet, which is the frontage of Fairfield Farm on those 2 lots?
That, I think, would be a matter of discretion for the commission, and I'll just give you one little war story. Circuit Court in Fayette County once had a similar question, and they required the road to be built to the end of the lot, not just to the part that the owners were going to be using, because in that case, the driveway was 50 feet from the front of the lot, and they made them go another 200 feet. It was a very long lot. I think they were wrong then, but that, I think, is not an illegal kind of decision. I think that would be reasonable. I just think it's probably better to say you do it what you're going to be using. But regardless, up to the end of the lot or up to, you know, a reasonable distance for the use of it.
Joe, am I seeing that right, or Matt, is it 391 feet?
It's much further.
For the one lot?
250 feet of width on a
Oh,
lot,
oh,
so
on both of them, that's
yeah,
right.
I think it's about 6 something, 6, 7.
I'm not seeing those numbers, okay.
So Charlie, on that though, would they not need the 150-foot turnaround at the end of that? Which would then have to be cut into Lot 10D, because in order for that, they would then need the turnaround at the end
Well-
of that section.
That's why my thinking is you just make them do it to where they have their driveways and what they'd use, because you're right, the rules say we're supposed to have a turnaround.
Right.
And since that's someone else's property, they really can't do that.
Or the developer at this time could modify their plat and put the turnaround in 10D, but you got a sinkhole there that they can't build in that corner.
Well, again, which is why my thinking is, we've allowed this thing to deteriorate to this point. We require them to bring it up to county standard, not that the county's gonna pick up the road for 2 lots, but through their access points. That way, there is no need for the turnaround, because you're right, that's another rule. But this is not anything like the usual situation.
Right.
You know, the road should not have been allowed to deteriorate. But that would allow them reasonable use for lots that do in fact satisfy our standards. It would get at least the first portion, and it would be, if you will, tantamount to their contribution, you know, toward the whole, except the whole's not gonna happen, so they would be doing at least as far as their own. And I, even though I like the idea of them having the same restrictions, building-wise and all of that as the rest, as we've discussed before, that would be part of a workout. We can't require them to join somebody else's HOA, especially when the thing was never put into work. So I would suggest, just as a good neighbor kind of thing, they need to adopt those standards anyway, as far as, you know, building materials and whatnot. But as far as the road goes, as far as they need for access points, bring it to county standard, they get their lots, and then, you know, the original ones still have to figure it out as they go forward.
Thank you, Mr. Perkins.
So, Mr. Perkins, something's been said a couple of times, an undeeded right-of-way. Mr. Dugas talked about it, and someone else also.
If it's undeeded, it's still owned by the same people,
That's what my question
and that's the
was gonna be.
developer.
So can the developer limit access to this undeeded right-of-way?
No, it's undeeded in the sense that they haven't taken over full responsibility. It was still dedicated as a right-of-way.
Okay.
And I don't think anybody, although I've come across some ridiculous judges in my day, none around here, of course. I don't think
Good save.
anybody would say, since the HOA, if it ever existed, hadn't taken title, that they couldn't improve the road and so on. It was dedicated for that very purpose.
Okay,
So, no, sir, that I don't think is a problem.
all right.
Thank you.
I've got a question for Ben.
Ben, would you come up to the microphone?
We've survived it, Ben, you will too.
Would it be possible to figure the cost of the road at that original standard and hold the developer responsible for that amount, and then to bring it up to today's standard and divide that by 11? Can you, I mean, would it be possible?
Anything's possible. I didn't understand that.
The
but-
Wayback Machine?
Yeah, but think about this, Charlie, before you answer, Ben, when he brought it up to standard back 15 years ago,
Yeah.
he had that expense
Yeah.
Yeah,
I
yeah.
understand
back
that.
then, so why would he be responsible for that again?
Well, that,
I mean, again, it is the perfect
But who owns the
storm.
road now? That's,
Everybody.
Developer
Yeah.
still owns the road.
Yeah.
Yeah.
But it's subject to the right-of-way that was dedicated back in '04 or whenever
to
that was.
all the owners.
Yeah.
Yeah. I was just trying to come up with a solution. Mr. Sims, you know, felt like the developer was only responsible for these 2 lots, and the homeowners felt like that the developer was responsible to get it all up to standard. But if you got it up to the standard that was needed at that time, if he paid that cost and the homeowners paid the additional cost to get it up to today's standard, I don't know how much that would be.
Just to clarify, when we did have our informal negotiation,
Uh-huh.
the homeowners did not ask for the developer to pay the entire cost. We said we would be willing to come out some, and between this and that, this is where we were at.
Okay.
We never really got any closer.
All right.
So.
So you
the
did make.
the homeowners are, and again, I can't speak for all of them, but I have spoken to all of them. And yes, the homeowners are not asking the developer to pay 100% of the cost,
Gotcha.
but the homeowner, the developer
But you feel like it ought to be more than 2/11.
ought to be, again, based on the history going all the way back, has a little bit more of the lion's share than everybody else.
So you're somewhere between $0 and $100,000 apart.
Correct.
What if,
Big range.
I like Charlie's suggestion.
Charlie's suggestion, I went out and measured it. I got 915 feet out of 2,300, which was 42%, it ended up being 42,000. When we sat down and had our discussion last week, I said, this is a good starting spot, 42,000, and the rest of the homeowners would be looking at that. Again, not a formal negotiation, because I can't economically bind 8 other homeowners. I said, that's a starting point. That was a non-starter, we're not even talking about it, walked away.
Seems like it's in everybody's best interest to come up with some solution, because with or without the lots, the road's going to continue to degrade, right? The only possibility of any improvement in the road is with the lots, right? I mean, as we sit right now, unless the current homeowners want to front the entire cost, right?
Right.
Because the county, I mean, unless they get some grant or something, I don't anticipate
Right,
they're going to come
the
pay for
issue
it.
becomes like I said, myself and Mr. Brown, who is on lot number 7, he's also a public employee, he has construction and road experience. Our concern is, even though we've got a quote for $112,000, that once you start tearing up that road, because the road bed is what has failed, that 112 or 120 is going to quickly escalate. And, how much is this going to end up being?
All right, yeah.
And then at the end of the day, there's still no guarantee that Mr. Brandenburg is going to come out there, and I know it's not his yay or nay, but everybody knows how the fiscal court works. If JR gives it a thumbs up, it's going to come in. JR gives it a thumbs down, there's no way it's coming in the county system. So ultimately, that's where the majority of the rub is with the homeowners is, if we could get the county to agree, hey, we give $10,000 apiece to the county and the county takes it, and if it ends up costing whatever, that's on the county, because there's not a homeowners association, and then the county can fight with a contractor. 9 separate people can't come together, get that, and fight with a contractor that doesn't meet the standards because we're paying for it, but it's got to meet JR standards. So that's, again, now let's talk about the perfect storm. You've got all this, I've got a contractor over here who wants to do the least amount of work, who's going to probably find problems that, undiscovered conditions, et cetera. So, that's $11,000 is not going to cut it. You don't ever go into a construction project without a contingency. And we're already at 120. A contingency on this, again, because the road has already failed 3 times, okay? You're probably going to be looking at, if this was a job I was bidding for the city of Lexington, I work for Lexington Fayette Urban County Government, I would not put this out for under 100. If I didn't have a budget of $175,000, I wouldn't recommend to council that we move forward.
Charlie, I've got a question for you as our attorney. Ultimately, whose responsibility is it to form an HOA? I've heard, I live in a ball home subdivision, so I know how they act, and I think Mr. Dugas says he works there.
It's been done both the way Doc read to us. It's been done with the developer doing all the formalities, and literally, it's a complete package when it's turned over. I've also seen many with a complete package that then screwed that up. And then some, it was done perfectly, and nobody came to a meeting ever, so it still didn't happen. That's all over the board. And I frankly think it's pretty much irrelevant. According to the restrictions I believe that Doc read, though, the responsibility clearly were the lot owners, not the developer. That their part was over when that thing was signed. We can't get into that anyway.
Right.
All we can do is make sure that there is a document in place that sets out responsibilities. We have absolutely no say as to who gets the responsibilities or how we get back at them if they don't live up to them. All we can do is take care of what's on our table, which is these 2 lots, and the road that we can't have more than 3 on that's not up to standard. Well, and that's only these 2, because that's all that's before us. All that other stuff is literally beyond us, period.
And we have an application with no variances.
That's right. I mean, so this is just, this is black and white. I do think it is essential that we require them to bring that road up. And I think it's probably overreach to say the full length of their lots, just like I thought it in Fayette County 20 years ago.
But up to the access point.
But absolutely, up to their access points, because that's what they're going to be using.
Matt,
And if they've
did you
got a farm,
determine
we
how
can
many
just
feet
allow
that
them to
is,
do it.
in case we need to put it into a motion?
Higher frontage would be about 860, 870 feet.
But it doesn't have to go that far, it only needs to go to that.
That's what I would think, because it isn't, I mean, these lots don't have the need for that.
Right, and I noticed the access on the second lot, lot 10D is pretty close to Highway 460.
Yeah, it's clearly not going to be toward the
Right,
far end of
800,
the
it
lot.
probably is about 500 or 600 feet.
Yeah.
Mr. Perkins, I guess my question for you, and this might be Mr. Krebs' question as well, as with the way the deed is stated, say if there were ever an accident on that road and road conditions as they sit current were deemed to be a cause, who is liable at that point?
Well, yeah, I can't really speculate on that because there are a lot of moving parts. But if someone came to me and had that accident and I was looking at the paperwork and the first thing I read was the homeowners association was responsible for maintaining it and they never did anything, I'd be looking long and hard at possibly filing suit in that direction. Fortunately, I don't do that kind of work. So I don't have to do it. And I may be wrong. I don't do that kind of work. But clearly, responsibilities are set out by contract, and contracts are in either deed restrictions, like you said, these were filed, so therefore they took their deed subject to them, and that locked it in. When someone bought that lot, they had not only their deed, but they had the conditions set out in the deed of restrictions. We can't touch it. We can't say, oh, that wasn't a good deal. We're going to change. We can't do that. That's what they've got. All we've got, 2 lots, and as much of the road to make sure that we're not putting more lots on as substandard road. And we can't make them improve, in front of anybody else.
Thank you, Mr. Perkins.
Mr. Chairman, Harold Sims on behalf of the applicant developer. Just a couple items. The idea of the notion of everybody kicking in a few dollars to giving it to the fiscal court and saying, well, here's our money, take over the road. I think that the way I read this statute is there's a KRS in place that precludes the county from accepting this road if it's not at standards. So I don't think it's a matter of JR giving it a thumbs up or thumbs down. There's some state law that says they can't accept it now. It's not a political matter anymore. They can't accept it if it doesn't meet current standards. So it's a little bit more involved than the good old boy saying yes because we got a few dollars in our pocket. My clients built the road, paid to have the road built according to the then applicable county standards when this started. Thanks to the historical context that Ms. Hamilton brought us tonight, I now understand why there was this lull in it being taken over because they didn't have the requisite number of houses sold during the recession. In that period of time, as the road started to deteriorate, my clients have made a couple rounds of repairs to the road. Mr. Dugas tells me that he and his neighbors have gone out and filled in potholes and things on their own too. So, but my clients who paid to build the road to the then stated standards did so. They have gone in now twice to make upgrades to it. To now come in and say, we need you to fix the road that these other people have been driving across for 15 years. We want you to fix you paid solely the cost to fix the road in front of 10C and 10D, as opposed to saying, here's 2 more lots, we're gonna add, instead of having 9 people now, we're gonna have 11 people dividing the cost of this road. I think there's a substantial savings to the other lot owners by 10D and 10C coming on board. I think it makes sense to allow the 10D and 10C could move forward. And if the other group isn't moving forward with an association, they start an association and make an assessment. Whether or not we get anybody else to join, it would, I think it's mandatory. It says they shall operate as an association at the point in time that there was the final grade of asphalt on there. They didn't do that. So to now to penalize my people after the other group have been driving across it for 15 years without having everybody kick in equally for the cost of the repair seems to be a bit burdensome and unfair. And I think the application as we have made it will create 2 more people, 2 more lot owners to pay for the repair of this road. And it may not come easily, but I think we could, I'm sure those people back there do not want to turn their road into a gravel road. If they, if that's the case, then at some point in time, these people may decide to fix their road on their own. But but I don't know why they would try to do so if everybody else is going to continue to drive over it. We prepare our road, and then people that haven't paid for it continue to drive over it without paying for it. It just seems to make sense to do it this way and let everybody contribute equally. Thank you.
Mr. Chair, it might make sense, but we have no authority over the other 9 owners.
Correct.
And as far as driving over what they improved now on those 2 lanes, well, they dedicated that right way 17 years ago. So of course others are going to be driving over it, but they need to bring it up to county standards for those 2 lots because that's what the rules say and that's what.
And our job as a commission, and we have rules that we have to follow. To Charlie's point, we do, it seems like, need to and have to probably add condition number 6 that the applicants pave to that, at least their second entrance, which would be track 10D, that proposed entrance off of Fairfield Farm Road. That would be.
Specifically bring it up to county
That would be
standards.
bringing that portion of the road to county standards.
Yeah.
What we don't have as a commission is the right to require or make the other 9 lot owners make them pay to bring it up to county standards. That's gonna be up to them to
Yeah,
put
that's
in that
all
money.
now private obligation and we can't do
So,
that.
with that being said, we can go on, Mr. Dugas, all night long, and I'll be honest, I got a
Well,
bedtime.
Right. One of the things that Mr. Perkins brought up is the fact that this board can't potentially make those lots come into the homeowners association. Well, if the homeowner association is responsible for that road, this was what was brought up in August, now you're turning around and giving 2 people access to a road that you're saying I have a contractual obligation to maintain, but they are not necessarily gonna have to maintain it.
But what I
know they're saying-
understand.
But I'm saying you're opening up, by saying that, you're opening up again.
Yeah. Well, what I understand though is, and not to Mr. Guthrie's fault, not to your fault, not to any of the other people who are in this room who live on that street, he followed the rules, he had it paved up to the county standards back then, whether it was in 04, 05, 6, or 7. He did not and could not dedicate the road to the county because unfortunately 50% of the lots weren't built on. So he did everything he should have and needed to do based on those current laws. Now the standards are higher, now the road's been tore up because the last 4 lots weren't completed until the last 36 months, as you stated. You know, it is a little of a hot mess, but everything I think was done legally by the applicant. Unfortunately, there was not an HOA formed. I don't know, I don't think it's anybody's fault, not yours, Mr. Dugas, not Mr. Guthrie's. But had you all been saving as an HOA, and anybody who's in an HOA knows, you're paying an annual fee for these type of situations, whether it's to, you know, maintain or improve the subdivision. And if no HOA was formed, and again, not your fault, not Mr. Guthrie's fault, but 15 years worth of savings, you probably could have went, you know what, we can pay for this now because the road's deteriorating.
And to Doc's point, I would agree that it would certainly from an efficiency of scale standpoint, probably makes sense to do the rest of it at the same time, but that would be something the other homeowners would
Need
have to
to-
say,
need
okay,
to- yeah.
here's what the estimate is, we're gonna do it now, or we're gonna hold off. and do it
Versus, like
later.
you said, daily, it's going up. So 5 years from now, instead of 12 or 11,000, it may be 20,000, and you hate to say it, but eventually somebody's has to step up, and the county's not, to Charlie's point, county isn't in the business of paving roads when they're not, part of the county system. So until that road's brought up to standard, the county's not gonna pay for it, and it's just gonna keep deteriorating, and everybody's gonna have to use their four-wheel drive.
I'll make a motion for approval with the addition of a sixth condition.
So the sixth condition being,
Bring the,
Well, actually,
sorry.
I thought, if I might, just a second, I thought what we'd do is take condition number 4, which
And
talks
adjust it.
about access to Fairfield Road and part of the HOA. We'd strike the HOA part and just say, and then bring through their access points up to county standard.
approval with the condition 4 change to read
Yeah, let me
that,
just read the whole thing
Okay.
rather than trying to just paraphrase. The new tracks shall have access from Fairfield Farm Road and shall bring through their access up to current county standards. And strike the part that requires them to join a homeowner, because we can't make somebody join a third party's homeowner. Well, this is theirs, and they're gonna have to do it, so, but you're right, but that it probably should be on the subdivision plat that's approved. So, yeah, we'll make that a condition that then needs to be a note on the plat, so, yeah, very good.
Doc Sims, we have a motion, but do you have a comment before we?
The condition is new, and I need to be able to advise my client. I just have a question. We bring the road up to standards all the way down through 10D, and then, so the road is at that standard. So then when you get ready to fix the balance of the road all the way to the back, are my clients expected then to kick in as a member?
that would be
No,
your
they're
211s.
not a member. You read to us, they're not a member, and we can't make them a member. And if they're not gonna participate, we wouldn't want to make them a member.
And that's equivalent to their 211s doing that.
Charlie, can they
So we will-
dedicate that, it's gonna be about 500 to 600 feet, give or take. Can they, once they, bring that portion of the road to
That's up-
county standard, can they dedicate that 600 feet?
I
No?
have no idea.
Ben, do you know that?
I would say not, but I don't know.
Okay, all
that.
right.
So let me ask, can I ask a
You
question?
sure can. We just have a motion only.
In 4, it says, new tracks 10C, D, and partial A. Now, who's
That's
going,
that's an unbuildable thing across.
it's unbuildable, right. But you're gonna have access to it, so shouldn't that be part of the
So
shouldn't
they
that
could
be
go lower.
112
I
instead of
can't
111?
imagine- I really can't imagine.
But they can't build on it.
Well, first off, again, we're
Who's
not
gonna
being
use it,
able to assess shares of responsibility. All we're dealing with are 2 buildable lots. And all little A is gonna be, I would imagine, is the access to go over and mow the thing from time to time. So, we're just saying, through their access points, they gotta bring it up, because we can't have more than 3, and we've already got 9, on a road that is not
Substandard road.
county standard.
So we
But it's not through 10D, it's through their access point.
Yeah, it's only up through the proposed
we
entrance.
we're gonna get two, assuming if the vote is affirmative and this other condition is modified, 10C and 10D are going to become new subdivision lots that are not connected to Fairfield Farms. They're just 2 subdivided lots, and that they can sell them without any restrictions on them that complement the rest of the neighborhood.
Well, I
think
think,
that's-
I think they should sell them with those conditions.
I know
No,
you
sir, we
should,
have-
but you said
we
that
have
it's
no
not,
obligation-
no obligation.
responsibility.
We're offering to make,
Yeah,
to
we
do
can tell them
that, but we
that-
don't have to at that
No,
point.
we have no authority on standards like that at all.
And nor would we have any obligation to contribute to the maintenance of the back part of the road.
Although they could do both, just to be neighborly.
They could, and
And you can spot them some money too.
Girls, come and dig in your pocket, Charlie.
All right, we have does that answer? So we have a motion by Mrs. Singer to approve with 5 conditions. And I
And the
either,
modification of 4.
well, yeah, 5 conditions with the modification of number 4.
I'll second that.
So I've got a motion by Mrs. Singer, A second by Daniel Smith. All in favor, say aye. Aye. Opposed? Motion.
No.
Wait, hold on. All right, I'll do a roll call so it'll be easier. Well, who's opposed? Joan, so, let's do a roll call, just to make it more official. So, we'll just, so motion, a yes would be to approve the Fairfield Farm subdivision. Mrs. Singer?
Yes.
Mr. Shirley?
Yes.
Mr. Mifflin?
No.
Mr. Vest?
No.
Mr. Stone?
No.
Mr. Garrett?
Yes.
Mr. Dan Smith?
Yes.
Chair votes yes, motion carries. Thank you all for coming.
Get you high.
You can go ahead and sign
Brett,
with
did he get you? Oh, okay.
Mr. Perkins. Moving on to next application on the agenda. What did I do with it? There it is. ZMA
Now what happens?
2021. All right. ZMA 2021-34 Leaf and Barrel zoning map amendment to change the zoning district from A1 to B1 located at 1442 Delaplane Road. For the record, this was a public hearing last month. We heard everybody last month, and we closed the public hearing. So what this is now a continuance for, I think the neighborhood had a spokesperson and probably the attorney, which if I remember is Mr. Cato, and maybe have some discussion and the commission, because I think a couple of commissioners had gone out there. We had kind of familiarized ourselves with the project. So, Matt, is this yours?
It is.
All right.
I guess I was just gonna start by asking you if, would you rather, since my staff report has not changed since last month, would you rather I just give an abbreviated presentation, or would you like to hear the whole thing?
I would say abbreviated, because I think just about everybody was here with the exception of Mr. Shirley.
Yeah, so there we go. Let me advance a few slides. As you mentioned, this is a zoning map amendment. The applicant is requesting the property be rezoned from the current zoning of A1, which you can see here on the screen, the property at 1442 Delaplane Road. They're requesting that the zone be changed to B1, which is a neighborhood commercial zoning district. This is a screenshot from the future land use map showing that most of, or almost all of the property is located within the urban service boundary, was planned for commercial use or designated as a commercial use on the future land use map as part of the comprehensive plan. Skipping ahead a little bit more, if it will let me. Just brief reminder, when we look at zone changes, state statute, KRS 100.213, directs us to look at the comprehensive plan for our community to determine whether or not that request is appropriate. So the first part that we look at is whether or not the proposed zone change is in agreement with the comprehensive plan. If it's not, we look to see whether or not the existing zoning classification is inappropriate and whether what the applicant is proposing is appropriate. And if we don't find that one either, then we would look to see if there have been major changes of a physical, economic, or social nature in the area that makes the zone change necessary. In this particular case, and as I went over last month and is in the staff report, I do find that the comprehensive plan, both the future land use map and many of the goals and objectives support this application. I did have some comments that I go over in the staff report regarding the character of the area and how improvements to the site should not detract from the character of the area, and we had some discussion on that last month. But I do find that the proposed zone change is in agreement with the comprehensive plan. I did also want to point out one thing that we touched on briefly last month, but we didn't have very much discussion on it. If you all do recommend approval of this application, I think you should give the applicant the guidance as far as whether or not you're going to grant them a waiver on the requirement that they connect to public sewer, because that is something that is required in our subdivision and development regulation. So that would give the applicant some clarity as far as how they're proceeding going forward, should you all recommend approval. But I do recommend approval with the conditions that are listed there in the staff report, there are 5 of them. Most of them are, you know, similar to what we would have on any zone change type application. You know, I do kind of go into detail about, you know, when they may need to connect to public sewer, should you grant them a waiver, and/or when they should annex into the city. Some of those are contingent upon what other properties in the area.
Matt, would condition number 2 not cover that? Applicant shall request annexation either when public sewer is available to the site or an adjoining property or another property on the same section
Yes.
of Delaplane Road be annexed.
It would. My recommendation is to grant them a waiver, but that is something that you would have to do. If you decide not to grant the waiver, we would need to change conditions 2 and 5.
Thank you.
Yeah.
Any questions for Matt? So we'll keep moving and bring, I guess, the applicants up.
Good evening. Zach Cato. I'm here for the applicant again. It's good to be back again this month. My understanding is we're basically going to give an update as far as what's happened, the discussions, any new information from last month, and not rehash it. So that's what I'm going to do. I'm going to go through it briefly and touch on a few things that are implicated by those discussions, but I'm not going through an entire, I've got 10 slides to show you, so it's not going to be a real long,
Perfect.
drawn-out thing. So as Matt pointed out, this is a zone change. It's not a development plan like what we just looked at. So we're looking at just a zone change with a concept plan for this property. There is no new development proposed at this property. There's no building, there's no construction, there's no new impervious surface, nothing. They're reusing the building as it is now, the smaller 1,400 square foot building that's there now. So since the last hearing, there's been some neighborhood meetings. I think the neighborhood's had at least 2 meetings that I've learned about. I was not invited to them. The applicants weren't invited to my knowledge. And then there was a meeting that I set up at the commission's request with the neighborhood by Zoom, sent out letters to everybody in the notification area, plus anybody that spoke last time, anybody that provided contact information. There was about 13 or 14 people on that call, excluding myself and the applicants. It kind of varied because it's Zoom, people come and they go. But that's roughly what the participation was. My understanding is the neighborhood sort of selected Brad Green to kind of be a spokesperson to kind of rebut and give his perspective on things after I'm done to streamline the process tonight. I don't know if other people are going to speak, but that's what I've been told. There's not really been a lot of new information or progress. We have had some good discussions. They were productive discussions. It was much less lively than it was during the Planning Commission hearing last month. It was a good conversation, but we did not make any real progress. It was a lot of the same questions and concerns, a lot of the same responses for me as before. We just have fundamentally different ideas for what should happen at this property. Really, the takeaway that I got is it seems like the neighborhood in general, I'm not putting words in their mouth, but the interpretation I've got is that they don't really think there's much need or role for any commercial use out in this neighborhood right now, that it's a rural neighborhood and that there just shouldn't be commercial uses out there other than what's already there. A lot of the questions were what-if questions that came up during our meeting. You know, what if the lounge fails and they want to rezone it and do something else? What if the lounge is successful and they want to expand it in a few years? What if somebody gets overserved there and something, God forbid, were to happen as far as having one glass of bourbon too many? A lot of what-if questions, but not a lot of discussion about whether or not the zone change is appropriate or whether or not there's a way to make tweaks to what they want to do to make the neighborhood happier with what they're proposing to do. So I'm going to go, this looks like a lot, but I can go through this pretty quickly. This is basically breaking down the categories of the the comments that I got generally. I'm not going to say this is all of them, but this is basically how the feedback breaks down. One of the big ones is light pollution. We don't want to see a bunch of lights kind of impacting our nice rural view. It's pretty dark out there. We've already agreed, and one of the staff conditions is to make sure that the lighting is not, overly impacting the neighbors. So we'll install shoebox-style lighting or targeted lighting to make sure that it's not going further than it has to go to serve the purpose for security and being able to see where you're walking when you're out there at night. Not big, bright, security motion lights like you see out in the country, like I've got on my garage that just goes everywhere. Not that. The signage, as we've agreed in the last public hearing, it'll have to be compliant with the zoning ordinance. We have to make sure that it's approved and that everything is good with that. But we're not proposing a neon sign. We're not proposing an LED board, nothing like that that's going to really jump out and be a distraction out there in this rural area. It'll be a small, externally lit sign in compliance with the zoning ordinance. And if they try to do something more than that or something that doesn't comply, we've got code enforcement violations that can be done to address that. So that issue kind of takes care of itself. As far as noise pollution, the proposals for an indoor lounge, so other than traffic, people coming and going to their cars, we're not anticipating a bunch of additional noise. There will be some people coming and going, but it's not nothing tremendous. With the screening, there was some requests for screening and concerns about, well, what if somebody has too much to drink and wanders onto my property? The first thing is, well, there's not fences out there now, so nothing really stops that from happening as it is. But as one of the staff's recommendations and what we've agreed to do is to screen off the lounge area, the parking area from the remainder of this property where that lumber operation is, which will discourage, if not prevent that entirely. Now, if somebody goes nuts and just goes trespassing, they're going to have to trespass across our property first to get to somebody else, or they're going to have to cross the road. So we can't say it's never going to happen, just like we can't say it wouldn't happen today, as things are. But the screening will be there. Traffic was another concern that was brought up. What's going to happen with the additional traffic? The fact of the matter is this operation is going to be limited to a 1,400 square foot existing building. There's only going to be so many people that can be there at once. And they're coming for longer periods of time. It's going to take you 45 minutes, an hour minimum if you come in to have a cigar, maybe longer. Whereas if it was a neighborhood market or a restaurant or something else that could be done to commercial zone, it'd be much more frequent, quicker trips, a lot more traffic, a lot more trips in and out. So this use is very low intensity compared to some other things that could be done in commercial zones that would serve this neighborhood. Impaired drivers, we understand the concern. We've got dram shop laws. We've got ABC regulation and training that has to be done. We've got DUI laws on the books. There's a lot of framework in place to address that goes beyond what the zoning of the property is or what the commission's in a position to really address as far as a future concern. The possibility of a future expansion or a future change. We're here today with the proposal that's in front of you today. We don't know what's going to happen in the future. We hope this is a successful business. It may not be. Or it may be so successful that they want to do more. Whether they want to do that here or open a second location, we don't know what the future holds. But the bottom line is, if something changes in the future and it requires a rezoning, they're going to be back in front of you. If something changes in the future that requires a development plan, they're going to be back in front of you. Public hearing, unless it's something really minor that could be done on a minor plat. Or they're going to be back in front of the city for a building permit. There are processes in place to go through no matter what happens in the future. And then lastly, there were some concerns about the aesthetics of the existing property, that it doesn't look good. One of the comments was there should be a wall built basically on Oxford Village so that you can't see the lumber operation from the street. And they said it was safety and aesthetics, but really that's outside of what we're here to talk about. And it's outside, I think, what the commission can really do, since we're not asking for anything to be done on the lumberyard part. So that's kind of the summary of the feedback we got when we had these discussions. Excuse me. A lot of these have already been addressed either through staff conditions, which we agree with, and through things we're willing to do. The ones that we can address have been addressed already and will be addressed as conditions on this property. So since the last hearing also, we got a letter of support from the executive director of the County Tourism Commission, who gave a letter I've submitted to Matt about that. And unbeknownst to me, the client drew my attention to this yesterday. You can see in the lower corner, I took a screen grab yesterday evening. The news graphic ran an online poll. Looks like they posted it December 2nd, and it was updated on the 7th. It says, do you support a cigar and bourbon bar potentially opening in the county? And as of last night, the results were 57% yes, 43% no. So there is some community support for this out there.
By chance, you know how many votes there were?
I tried to find that out to see how many, and it doesn't say.
Okay.
So I don't know. Sort of wrapping this up, one of the things that came up last time that was discussed again in my meetings with the neighborhood is we bought our property because we like the rural nature of it, and you're going to change that. And I understand that. I hear that. That's a concern I know you all hear a lot too with all sorts of applications, zone changes, development plans. We've already heard it tonight. It's not something that's uncommon. So I went and looked at the future land use map from 2006. This is available online. This is what the future land use map looked like in 2006. The red is commercial uses. You can see that little dot right in the middle on Delaplane Road is this property. So for at least 15 years, the county has decided this is a commercial development area. Whether it's in 2006 or 2026 or 2056, we don't know. But this is the law of Scott County in the comprehensive plan, and it's been decided a long time ago. So the question is, does this application comply with the future land use map? Yes. And does it comply with the comprehensive plan? Yes, it does. We understand their concerns. We're going to address those through the conditions, which we've agreed with. Staff's going to have input on the lighting and the signage, we know, but this is an appropriate application and appropriate use for this property. The last thing is on the issue of the waiver. Matt covered this pretty well. Essentially, it's going to be cost prohibitive to bring that sewer across Cynthiana Road for a 1,400 square foot commercial use that has no food operation or anything. That would cost a lot of money to do that for this. I think what it's been clear from the feedback from the neighborhood is that they have no interest in being, and they can correct me if I'm wrong, but I've not heard anybody say that they want to be annexed into the city or that they are looking to develop their properties anytime soon. So there's not really any need for annexation or for a public sewer connection out there today. It would just kind of be an undue burden to require that at this time because of the cost and the expense of doing that for this one small, very small operation. The other thing to remember is the applicant is still going to have to get the septic that's out there up to code, certified, and approved by the health department. If they can't do that, they can't open. If they need something other than what's in place now, they're going to have to do it before they can open. That's the law that everybody has to follow, and they're not going to get any special treatment on that. So there is an adequate alternative in place to requiring them to connect to public sewer and to be annexed into the city. In the future, if there's more people that want to develop, there's more need out there, or there's a big development proposed, if a farm was to sell, that may be a different issue. We think that condition 2 appropriately addresses that the staff's done. Chairman Solsky asked that question earlier. We agree with that. That's the position that we have. So we would ask that that waiver, to the extent it's necessary, be granted so that we're not required to connect to public sewer at this time. If we ever redevelop, we'll do it then. Clicker is not cooperating. So I'm not going to repeat my summary. You've heard what I had to say. I do have a motion to hand out copies of it. Trying to put it on the board so everybody can see it. There it is. And I'm happy to answer any questions you've got. I appreciate being in front of you again.
So is this your request for the motion to read? Well, we don't entertain motions given by attorneys in regards, because Nathan Billings has done this before, and he's trying to dictate what we're going to make as a motion, so we wouldn't entertain your motion.
Okay, well, I'll just tell you, it's a proposed finding. The tweak, there's a tweak to a condition that I've suggested, and here's what I'm really getting at. I'll just tell you what I'm getting at, is with the lighting, the wording was least impact on the neighbors or something. The least impact is 0. And that may not be, I mean, if you put one security light out there, there's going to be some impact. So my suggestion is to tweak condition 4 to say in a manner to reasonably minimize the impact. So whatever, lighting that can be addressed to do that, to not have it shining out on the other properties, to require them to do that, and they will agree to do it. But we can't promise 0 impact.
Right, I understand.
That's just impossible.
Joe, how would you recommend we word that instead of have the least impact? Because to Mr. Attorney Cato's point, least impact would truly be 0. Can we reword that as, I'm trying to think how we did it planning and zoning, where we had the lighting where it's minimal. Maybe we can change that to minimal impact. And I think we do that with one word.
Yeah.
Okay.
If I might just point out, that's really a development plan, that kind of thing. That really isn't
True,
some
not a
change
zoning.
kind
That's
of
true.
issue.
We would address that.
So I think at the very least, he knows, and we need to make it clear that it's going to be minimal or it's not going to be approved.
Right.
But that really isn't a.
That is true.
zoning
It doesn't
kind of-
with zoning. We don't worry about that at this point. So it become with the
But
development.
that's what we stress that on every application, so that's.
All right.
And we obviously know if we come back with any sort of a development or expansion, we got to go through the process, we got to meet it, we know what the conditions are, what are in here, what the expectations are, there's going to be no mystery to it, we're well aware of that. I'm happy to answer any other questions.
Anybody have any questions for Mr. Cato? Attorney
I did-
Cato, I'm sorry.
Joe, is this presentation and the things they committed to in the one matrix become part of the public record? Yes or no? There were several things that were not in our conditions. The matrix that said, here are the concerns of the community, and here's what we're going to do, and there were a couple things.
Well,
we said,
that's
and we
his
agreed to that.
presentation. We don't put that into
Right,
our
I just-
records.
Okay. So there's nothing binding about it
Yeah,
necessarily.
Correct.
The chair could accept that into the record, but the public hearing part, which is, the most important thing, that has already closed.
Right,
I just prepared it as a summary of kind of what was discussed.
correct. Thank you. No, if there's no further questions. Now, I do know on Monday night at the workshop, we had somebody who was going to be the community representative. Oh, there we go. Okay. God, it's a big crowd. So for the record, state your name and address, and then,
Brad Green. I live at 2609 Oxford Village Lane, just down the road there.
If you could, Brad, hold on.
Yes.
Record needs to reflect, he is still my stepson.
As far as I know, nothing's
So
changed.
if that doesn't disqualify him, I don't know what.
it might disqualify
And I'll
him.
let the record reflect, we all appreciate.
Don't
that
ever admit
streamlined
that.
process.
Brad, don't ever admit that.
No, you notice I didn't say it. I would like to present myself to you all with equanimity.
Thanks.
Yeah.
Appreciate that.
You've been hanging around Charlie too long.
I can't help it. I really was appreciative of a lot of things he said, because the longer I listened, I heard the points that I wanted to make, and he made them himself. He actually said they said the comprehensive plan is law. Comprehensive plan is not law, it's a plan. You're allowed to follow it, or you can choose to go a different direction for other reasons. And I'm not here to talk about what ifs. I'm here to give you those reasons of why we think this doesn't work legally to be changed. All right. Good evening, all of you all. Finally getting to my part. It is with great pride I stand here to speak for the residents and friends of Oxford. I hope you all are also living in a community with such peaceful neighbors. I hope when you all go home, you're able to find the same tranquility pulling into your neighborhood that we find when driving into ours. Other than Toyota Shift Change, we live in a quiet community. As you heard at the previous meeting, we have parents and children who walk and jog up and down Oxford Village Lane in the evenings. This is a residential rural community. We have a church and a lumber yard. It is quiet through the day and still at night. I farm, and my neighbors have all sorts of livestock and gardens on their acreage as well. We are the picture of a rural, modern community. And if you've had a chance to drive out there, you know what I'm saying. That's what we are. And I've got some pictures and slides, but my gosh, I sure wasn't planning to already be here this long. And you all are probably ready to get out of here too. So if you've had a chance to drive out there and personally see the site, we appreciate that. We believe, and since we live there, I would like to think that you would value our thoughts and opinions on how our community can grow and evolve. That this property and area is not the spot for a neighborhood bar, be it cigar or bourbon or otherwise. At this time, I would like to discuss the staff's reasons for recommending approval of the site. Staff states they received phone calls from property owners in the neighborhood concerned about the impact of this zone change, and that any zone change should strive to retain the character and heritage of the Oxford community. We are totally in agreement with that. And again, I would like to think as residents, we have some say in what that character and heritage is. We live there, and we invite you all to come out and see us. Even to someone who doesn't live there, is apparent that this is not a business or commercial district. We are a community of many farms and small families. And while staff writes that a B1 zone change is the least intensive of the commercial districts, this business does not by definition meet the permitted use of B1 zoning in an A1 community. While they will have retail sales, it will not be for neighborhood consumption. The business proposed will not be neighborhood friendly. It is not a place for families to gather with children or friends unless they can tolerate cigar smoke. And I have no problem with cigar smokes. I hope they succeed wherever they can find a place to go. I would also assume, but I have not spoken to nor know of anyone in our neighborhood that is interested in spending $600 to rent a humidor box for a year. However, I have heard from someone who lives farther away who could not understand our problem going against it, but was very much looking forward to driving over and having a drink at the bar. So, Objective CF 1.1, staff recommends for the site to be annexed in the city to maximize efficiency of city transportation and services. We are not in the city, and we have, as he stated, and I love it, he just hit these points, we have no plans of being annexed into the city. Why would you rezone the farthest part of the urban service boundaries to maximize efficiency? It seems as if your goal was to maximize efficiency of services and transportation, you would look to bring businesses into areas where that existing infrastructure is already in place. If you look at the comprehensive plan map, as he talked about, from 2006 to 2016, you will notice that in some places the urban service boundaries were actually pulled back toward the city. They were moved back. This shows what a comprehensive plan is. It's just a plan for what might be in the future, not what must be. We are going to be very involved with the updated comprehensive plan, which is in the works right now, and we will be doing our best to have Oxford and any land adjacent to Oxford Village Lane removed from the city's urban service boundary. We are a rural community off the main road and wish to remain that way at this time. Objective CF 1.4, preservation of prime farmland. While it is very true this site does not include any prime farmland, and as you can see from the pictures of the site, even if you could see the prime farmland, a zone change in cigar bourbon bar at this location would ruin some of the reasons for the people that live here for the prime farmland that they own. The same people who live here quietly raising livestock and gardens would then possibly be forced to move to another area, one that would resemble what they have now. At that time, with the sale of that property, is it possible that the next stewards of the land aren't quite so interested in the farming part and are more interested in commercial building? Again, forever altering the small historic community that we live in. Objective CF 3.3, preserving the quality and integrity of existing structures. This structure is a residence. It was a residence all my life. It is a home where Mr. Graves' grandfather lived when he ran the lumber yard. I remember that well. If Mr. Graves were interested in preserving this structure, I'm quite sure he could have rented it out to a family, or any one of the local employees would be interested there. This zone change in and of itself does not guarantee the long-term quality and integrity of the structure. It only guarantees it will become a cigar and bourbon bar at this time. This objective, CF 3.3, also helps us make another point. It clearly states the repurpose of the building. It says that in there, the repurpose of the building. By law, a business that has been grandfathered in, as the lumberyard has, cannot be repurposed or expanded. So you may say, well, that's why we should rezone it. Well, that's great. However, at that point, you were admitting the current zone does not comply with the existing business. A business that, although it has been grandfathered in, has never been asked to comply with codes or regulations of the business and building. And he talked about that, how, well, now we'll be doing codes and regulations. Well, it would be different than we've ever had to see, and we haven't complained about that. As neighbors, we haven't complained. When businesses are grandfathered in, that is just for the business being allowed to operate. It does not mean they cannot completely disregard code and ordinance put out by the state and the county. Objective EN 2.4, encourage small-scale operations. The applicants and their attorney have stated they wish to be like Jake's Cigar Bar. And I had pictures of this. If y'all had a chance to see Jake's Cigar Bar, know anything about it, it's really impressive. It's a great, if you get a chance to look it up online. They have tons of pictures. It's a cigar and bourbon bar at Brannon Crossing. And if y'all are aware of Brannon Crossing, what it is, it's a huge place off Nicholasville Road. The location they have chosen for their business is surrounded by dozens of other small businesses, driving commerce, helping to bring in customers not only to themselves, but also surrounding businesses within walking distance. That location maximizes city transportation services. There is more than ample parking there, and they are connected to a sanitary sewer. Their hours are 12 to 12 because they are not in a rural residential neighborhood. The pictures on their website also show some sort of electronic slot machines, and a business caters as much or more to the consumption of alcohol than the purchase of cigars. So cigar bar sounds great, Jake's Cigar Bar, but when you go to their website, mainly what you see is bourbon and drinks, which is fine. I don't begrudge anyone that. At Jake's, they also have plenty of outdoor activities with an entire area just for cornhole boards, horseshoes, and a putting green. It is to be expected for people during nice weather that you would want to go outside and enjoy your cigar and your bourbon outside. I would expect that. If I was going to go to a place like this, I'd want to be able to go outside. As we discussed in the previous meeting, where is the plan for any outside activities, and how will that affect noise, light, and smoke pollution with the neighbors' homes? This is just my observation of Jake's that I took from the online survey, the online looking. And I only bring Jake's to your attention because in our previous meeting, you'll look at the minutes, Mr. Ledbetter and Mr. Cato both brought up about that's what they wanted to be. That's what they stated. We want to be like Jake's. There's Jake's. And in the staff report also has a list of conditions of approval. 1 and 2 says meet all applicable requirements of the zoning ordinance and subdivisions and development regulations. I noticed it didn't say some of the requirements. It says all applicable requirements. B1 zoning requires a minimum of 5 acres, or it must be connected to a sanitary sewer. Now, we recognize this is a rule that sometimes gets amended, and staff even addresses that by saying the applicant should request annexation when available. When will that be available? Neither you nor I know the answer to that question. 2 years, 5 years, 15 years, 20 years, and he even brought that up. He said, well, it's in the plan, but when's it going to be? If somebody buys a farm 50 years down the road, we don't know. And because this community does not want to be annexed into the city, I lean toward the longer period of time before that sanitary sewer is even in place to support a business that would grow. And we hope they grow where they get to go. Those things, that in of itself, should give you pause about approving this zone change. But have you thought, if you do approve this change, that you won't be approving one business on a lot that's 3.44 acres? They're asking for a zone change on 3.4 acre lot. They're going to have two businesses at that point in time on a small lot. Not just one, two. The bar and the grandfathered in lumberyard. Number 3, the development plan. Having now seen how this system works, I am shocked their development plan at this time is a printed picture from Google Maps with an area shaded in to show a parking lot with 12 spaces and dotted lines. There's 12 spaces and dotted lines, and council in the previous meeting said, we don't expect any more than 20 cars. You showed us a plan with 12 spots, and you expect maybe 20 cars. I don't know where they're going to park, and I know that's something for another day, but if you don't open this door, we don't have to go to that another day. We don't have to see that problems. We just don't believe you were given enough information to vote for this zone change at this time. But I hope you see we have given you ample reason to vote against it. Number 4, as he brought up license, this was perfect. He talked about what I'm getting ready to say. Lighting and signage shall have the least amount of impact on nearby properties or the character of the historic Oxford community. If you would like to guarantee the least amount, vote no. This area has no exterior lighting, and I had pictures for this, except the security light on the lumberyard and a single street light down on 62. I can tell you, I was up there last night. You all can drive out at night. It's dark. The intersections are dark. The intersection at 62 is dark. The intersection on Oxford Village Lane is dark. There's not any light there, and any light you add is going to be magnified by the fact that there isn't any light there. And they can talk that stuff about, and I'm not talking about them, but I'm talking about when your engineers, we're going to put this light pointing down. When they built that huge parking lot over in for the college, those lights are like, just constantly like I'm looking at all these lights all the time where there was nothing there before. So you're going to get that. You can't not get it. When you take no light and add light, you're going to have pollution. Number 5, any redevelopment or construction placement of new buildings shall require all habitable structures on the site be connected to public sewer. So if this business is successful, there is no room for growth without public sewer. Help put them in a place where this business could thrive. That place is not the community of Oxford, which is outside the city limits in a rural residential neighborhood with poor lighting at intersections that don't need the extra traffic. So, to recap everything I just said, it would add traffic and the consumption of alcohol into a rural residential neighborhood. It would add noise and light pollution such a business would bring to the surrounding properties. Landowners and taxpayers live here now because they wanted to be away from those things. A cigar and bourbon bar does not maintain the character of Oxford. Number 4, you'll be setting policy by rezoning an existing tract that already does not meet zoning requirements and still would not be compliant. In the last staff meeting, they brought up about, will the zone change make the lumberyard compliant? And he said, well, it'll make it less non-compliant. And to me, that sounds a lot like, well, she's just a little bit pregnant. Your approval, number 5, your approval would allow 2 businesses to operate on a tract less than the required 5 acres for one business not connected to a sanitary sewer. We respect the board and the difficult decisions they must make on a monthly basis. And I saw that tonight with the people here before us. I feel sorry for you all. That was an awful decision to have to make. No winners there, and nobody's fault either. You have to balance the good of the community, future growth, laws, regulations, rights of the landowners, along with the impact on neighbors and others. While I could continue on with other thoughts and concerns and objections, we feel these 5 things are ample reason to vote no. I thank you all for your time and attention listening to the concerns of the Oxford community. This is obviously a cause we all truly believe in, and I need you all to know that the words I spoke here tonight, I feel with my heart. And while I'm here tonight speaking for Oxford because I live in Oxford, if any of you were to come to me with a plan like this in your neighborhood, I would stand beside you to ensure the correct decision was made. We ask that you deny this zone change at this time. And thank you all so much.
Thank you, Mr. Green.
Brad, do you agree with Mr. Cato's characterization of the meetings in terms of there was dialogue back and forth? Just you weren't, didn't put you any closer together, but it was open on both
No,
sides.
and he and I had good talks, and we definitely understand each other very well, and he understands that we're against it. There's really no way to, you're fitting we think it's a round hole there, and they think it's a square hole, and the things just don't match. We do appreciate the fact that they would do everything they could to alleviate problems in the neighborhood. However, I've heard the wind blow before, and that's the way we feel about that.
Thank you.
Okay, any other questions for me?
Any other questions?
No?
Again, with that being, oh, go ahead, Mr. Mifflin.
I don't have a question for you, Brad. I do have a statement. Prior to 1988, when Toyota showed up here,
Yeah.
Oxford looked a little different than it does today, and there wasn't an Oxford Village Lane.
That was 62.
That was 62.
Yes, it was.
And Newtown Pike, and your dad and John Francis Cannon and a bunch of them farmed there.
Granddaddy.
And there weren't any 5-acre lots.
No.
And they, in these last 30 years or so, they have sold those out. So the rural community that you're stating is there now.
Yes.
You're saying it's a rural residential community.
Yeah.
It was just a rural community. You know, it was
Yes.
not a rural residential community. There were half a dozen houses out there, and that was it. And there were a couple little groceries and
There was one that closed in the 78, I believe,
yeah,
77 or
yeah.
78. And that closed way
There has been
before.
commercial there before, and things change.
They most definitely do.
And you've been part of that change out there, and so, you know, those lots have been sold off, and so everyone that lives out there now,
Oh, no, we haven't had that much growth. The only lots that were sold really in 5-acre tracts were where when the new road bypassed to preserve Oxford.
right,
Then you had that dead area in between there, and that sold off in 5-acre tracts.
yes.
But as far as
And you don't
anything else.
consider
in
that
Oxford-
part of the Oxford Village?
Oh, yes.
Okay.
In fact, the people own all the way around that, and this property doesn't even adjoin 62. That's one of the problems with it, too. It doesn't even back up to the main road. You know, there's no, any access to it's going to have to be off Delaplane or off Oxford Village Lane, and that's going to add more traffic to us, where if it were on 62, it really wouldn't add traffic to us, but it's going to be.
Realistically, most traffic can come off 62.
It should, except with this particular business, it's supposed to be neighborhood. I mean, it says in there, in their findings, neighborhood. These people are going to have to drive to get here, and they're going to have to
Yeah.
drive to get back. And if they're going anywhere toward Lexington at all, they're going through Oxford. That's where they're going. And maybe, and if Georgetown can support it that much that we don't need those people, then there's probably better places closer to Georgetown already ready for this, that it would suit better for them, you know. But I appreciate what you said. Yeah.
But you also understand that tonight, we're just looking at.
Oh, yeah, the zoning change. That's right. And that's why we want a chance to, with the new planning, the new comprehensive plan coming up, we're going to be involved in that to get that pulled back, where this won't even come back up again. Yeah. Thank you.
Thank you, Mr. Green. With that being said, and it was a continuance of last month's meeting, the public hearing was closed. Now it's our discussion and entertain a vote.
I've got a question for Charlie. Mr. Green brought up something that property sits on less than 5 acres. To his point about 2 businesses being on that less than 5-acre tract.
Yeah, and that's a serious issue. There are actually 2 points, I think, that are they're somewhat at loggerheads on that. Our rules are 5 acres or sewer. Ultimately, the only real final word on septic disposal, be it sewer or septic tanks, is the health department, well, actually, state plumbing department through the local health department. So as such, I think it's not inappropriate for a very minor, low-impact kind of thing that you probably could waive that because they've got to satisfy, the health department and plumbing have got to say it can or it can't. And so that's why the rule's pretty clear, but at the same time, I understand perhaps some need for flexibility. The difficulty is, yes, you're right, you've already got a business on it. I don't know what kind of impact that's got. And, well, I mean, that's just one of those discretionary things that, you're just going to have to figure out, I guess. But the rule itself is either you got 5 acres, you can do septic, or you got to have sewer. It's kind of funny because I'm usually the one sitting here saying, we got a rule, that's what you got to go by. And I understand staff's recommendation because this should be a very low impact. And we don't want to stand on arbitrary rules if in fact they aren't really needed in a situation. On the other hand, we can't have just unlimited discretion to make that call each time. That, otherwise, well, we don't have that kind of authority. We just can't do that. So you've hit on a very difficult call. Fortunately, we've got a health department, that does that call all the time. Otherwise, I don't think there'd be any question. As it is, it's still a serious question as to whether that's appropriate for waiver or not. Well, that's really probably the best I can do with it. We do have the ultimate septic disposal people in the health department and plumbing department, but on the other hand, there's a reason for the 5 acre minimums too. And usually that's what they are anywhere you've got an A1 zone, and of course that's the reason for, well, we've got to have B1. Well, then of course you've got the difficulty of B1 is for local service, neighborhood kind of thing. That's why it's called neighborhood commercial, as opposed to, it draws from far around, which is, at least historically here, been a B2 zone. So it's just, you got some difficult issues.
Other comments, questions, concerns by the commission?
Mr. Cato or Mr. Graves, have either of you talked with the health department about the status of a septic field out there?
No, sir. It was a family, as Brad said, the septic system was up to standards for a home. We expect our water usage, since there's no restaurant, no food service, there'll be a bar sink and a bathroom, and that's all. I mean, that's it.
But the health department hasn't been out there?
No, sir. Well, we haven't got far enough to get to that point yet.
Gotcha.
Well, with this being a zone change, I'll need a motion.
The septic system also supports that same septic system as what the lumberyard is on? No. There's no water at all there. But that's the second business we're talking about, right? So they don't, in terms of that regulation, it doesn't, 2 businesses wouldn't pull from it still.
I don't know that we've got any provision for approving businesses with no water or anything. So that's kind of an oddity right there.
I was gonna say, Joe, if you're gonna
I don't know how to
speak.
address that.
Yeah, it just came to mind when Charlie was speaking earlier. I'm not taking a side by saying this, but just to clarify, the 5 acre, that's for new lots. or new businesses. So if it's an existing lot of record,
Yeah, I
It
thought
can
about
be
it
utilized,
being grandfathered
but
in
the
as
health
well,
department
but
has
But that
to
doesn't
approve the
affect
septic.
sewage. That's.
Right, but I'm saying
That's
if
just your
it's-
basic use, not your sewage.
Yeah, if it's a legal lot of record, if the health department will approve septic on it, it can be utilized. So you can build a undersized lot if you can get the health department to approve the septic, if you can meet setbacks. So, I mean, that's, the 5 acre really is, the minimum is for creating new lots or building on, you know.
which it's existing buildings, that's what I was
existing piece of
thinking.
property.
And to your point,
But-
Charlie, it's the intent, you have to look at the intent of what the law was to start with, right? In terms
Well-
of two businesses pulling off the
Well,
sanitation system.
well,
and the
the
impact to it.
principal law, at least as far as septic goes, is from the very beginning, we want more, whether it be residences, businesses, or otherwise, we want them on sewer.
Sure.
We don't want septic tanks, which is why, you know, we've always just said you've got to do that. And again, I think the reason is here, this is a very, well, it's supposed to be a very low-intensity use. And, well, I mean, obviously, the lumberyard's been a low-intensity use for, you know, forever. So that's why this is difficult, because the policy's always been, when you develop something new, albeit they're not building, you go on sewer. If there's no sewer available, well, and anyway, as I said,
Depend on the health department,
it's a
too.
difficult proposition.
But the grandfather issue doesn't.
The grandfather issue is strictly the use on the property, and the use on the property right now is a vacant house and a lumberyard.
It has nothing to do with the sewer.
No, it has nothing to
But
do with it.
it doesn't have anything to do with turning this into a leaf and barrel either, correct?
No, because when you're grandfathered in, that's what you get. Now, when you change it to something, or you add something, well, then you've got to bring up your standard. So again, but it's a very low intensity, which is, I think, why, you know, we'll allow, you know, something new to come in that's not going to have adverse impact, and this is low impact. Well, I mean, I understand that, but that's not generally how we've approached it.
Thank you, Charlie. Any other comments? Motion to approve, motion to deny. If we get neither, Charlie, it dies, correct? And we've had this situation, it's been several years,
As
but,
I recall, I believe the statute provides that if you don't get a vote, you can continue up to 30 days and try again.
okay.
But I think the point is, we need to have a vote. Again, that may not necessarily be tonight. You know, there are deadlines in place, but I think if you don't get a majority one way or the other, I believe that's, and I haven't looked at that for a while, and probably should, real quick.
It's been a few years since we've had a continuance, I think, based on not being able to get a vote to approve or
But I
decline.
think I think the statute says, and I don't believe it's changed, that we can continue the thing for up to 30 days, and then bring it up again. But the point being, because if we don't have a recommendation one way or the other, then it goes on without recommendation. It goes on to the county, in this case, without a recommendation.
That's true, we could do that,
Yeah.
so, okay,
Which is a possibility.
could be. So anybody want to make a motion to approve or decline?
Mark, I feel both sides, really, but we're just voting for the zone change.
Correct.
Right now.
Correct.
And the other stuff is really going to be optional later. So therefore, I'd like to make the motion that we accept the zone change as projected, but hopefully to the apps down the road, they're not going to run into a lot of problem later, because it seems like to me, with septic and one thing or another, that there's going to be a lot of other things maybe going to change their minds down the road. I don't know. But anyway, as of right now, I'm move that we
So
have
I've
the
got a
zone change.
motion by Mr. Stone.
Mr., if I may make a suggestion to Mr. Stone, if you would expand your motion a little bit to say, based upon the staff report, because it's got findings and whatnot, recommendations in it. Because whenever we do a motion, particularly on a zone change, we need to have reasons, whether it's pro or con. So if you would just base that upon the staff report, that would
Okay.
strengthen our record consideration.
Based upon the staff report of the file number 34. Okay?
So I've got a motion to approve by Mr. Stone,
Second.
and I got a second by Mr. Shirley. Because it is a zone change, we'll do a roll call. Mr. Stone,
Yes?
Mr. Mifflin,
No?
Yes.
okay, Mrs. Singer,
Yes.
Mr. Garrett,
Yes.
Dan Smith,
Yes.
Mr. Vest,
Yes.
Mr. Shirley,
Yes.
and chair votes yes as well. Motion passed.
I do think we all clearly, I don't think any of us up here don't understand the concerns from the community. No,
Thank you.
okay, thank you.
Moving along, an applicant
Brad.
come up and sign that. And moving along, FSP 2021
Board of Adjustments all the time.
-39.
All this, you have like conception.
Give it a second, let them
That goes
clear
out
out.
the window. Like you say, we're talking about
Anybody
one
need a break?
situation, not their
Everybody good?
will.
I have to,
I know, I'm
Like you say,
okay.
they're-
I actually have another commitment at 8, I can probably squeeze that. But you don't need me for a quorum, but I'll stay late,
Well, I mean.
which will save me having a break now, too.
No, I
If
mean,
you,
I've done
if you wanted
Galvin's, I've done
conversations,
dentist
please take them
offices,
outside.
I've done yoga studios, this is not, and that's what these folks don't understand.
Mr. Graves,
And,
take that conversation outside. Thank you, sir. All right, moving along, FSP 2021-39, the Humphreys property, track 8. Final subdivision plat to subdivide one 6.4 acre tract, leaving a remainder 9.5 acres located at 4476 Frankfurt Road. Thank you. Wow.
Thank you.
Yeah, that's awful.
Should be moving along pretty quickly.
Yeah.
As you mentioned, this application is to create one new lot. There have been some changes since we discussed this project at workshop on Monday, and the applicant did provide the updated drawing, which I think I left a copy up there for each of you. The acreage has not changed. What changed, or the main change was that the applicant got some feedback from the transportation cabinet that the proposed entrance that they were showing on the one that was included in your packet was not going to be approved. So the applicant revised it to show that they will bring a portion of the existing driveway up to county road standards that we've discussed at somewhat length this evening, and they'll provide the turnaround as required by our regulations. So that's the main thing that has changed. So this is an aerial view of the project site. You can see there the existing driveway. US 460 is at the top of the screen, which is also the north, just for those of us keeping track of our cardinal directions here. And the newly created lot would be sort of on the left-hand or the west-hand side of the image that you see there. If I can get this to advance one more slide. There we go. This is a sort of a zoomed-in view of the drawing you have before you, including the updated entrance. I've included a zoomed-in version here if you look at the top left portion of the screen. Really, staff, between Ben and I, the only recommendation we have, at least at this time, as far as the turnaround that they're showing, is we do ask that be, instead of being 15 by 20, we do ask that be 20 by 20 gravel turnaround area, just so a vehicle has the opportunity to pull in. A typical parking space would be 18 feet deep, and so we just ask that be somewhat similar, so that things like garbage trucks or emergency services that may come in that portion, in that entrance, have the ability to turn around. I'll take it just a second. It really loves it when I have photos. The only other thing that I wanted to discuss with this site is we did get a comment from a neighbor that there may be multiple residences on the area that's shown on the plat as the remainder. And so I just wanted to sort of bring that up to the Planning Commission, because the remainder is shown to be about 9.5 acres. As you all are aware, we have a 5 acre, a 1 residence per 5 acre density a requirement in the A1 zoning district that this is in. So if that is true, and we have reached out to code enforcement to verify, you know, how many residences there may be on the site in use, you know, the applicant would have to, you know, should they want the plat recorded, would have to bring that down to a single residence, whether that be, you know, demolition or a change in use of some sort of some of those buildings.
Matt, have you drove out there? I mean, to see if there's,
Well,
multiple
we sent code enforcement.
Oh.
I reached out to Tim Thompson. He
had you
said,
not heard back from?
I've not heard back. He mentioned that they were going to look at it, but he hasn't reached back out to me on that. So that's just something to be aware of, you know, should you approve the plat. I have amended the conditions from what is on the copy you have in your staff report. If I can get this to advance the slide again, there we go. The first 4 conditions are the same in your staff report as what is on the screen and what Charlie has for the applicant to sign should the application be approved. The last several are different, and I'll kind of go over those. Well, condition 5 is, I believe, it's condition 6 on your thing. I got rid of the previous condition 5 because it was no longer needed given the changes that they had made to the entrance. Condition 6, as I'm proposing, just sort of requires that they construct that turnaround before they plat the lot. You know, that brings the access way or the driveway into compliance with our regs prior to platting. The condition 7 there deals with the, you know, changing that gravel area for the turnaround from 15 feet long to 20 feet long, as Ben and I had previously discussed. Condition 8 just sort of makes it clear that the tract that they're creating and the remainder tract, if they want to use that entrance, that area that's, you know, that will be brought up to county road standards, their access has to come off of that county road standard portion. They can't, you know, come further in the gravel area that's, you know, paid for and maintained by other property owners in the back. That's not going to be permissible. And we would ask that note be a note to that effect be on the plat. And then condition 9 just sort of states that, you know, the remainder tract is only large enough to, you know, as they proposed here, to support a single dwelling unit. If it turns out that there are additional dwellings, those need to either be, you know, demolished or some sort of change to make them, you know,
In
not
compliance.
not standalone dwellings, yeah, in compliance before the plat is recorded. But ultimately, I do recommend approval. For the most part, the plat, you know, meets our requirements. I think in particular, condition 9 ensures that we wouldn't be creating some sort of nonconformity.
Thank you, Matt. Any questions for Matt? Or Mr. Summers, I'm sorry.
That's fine.
All right, thank you. Would the applicant like to speak?
Hello, I'm Jared Stevens, working with Snowball Trust, Mr. Humphrey sitting over here. I wanted to talk about item number 6 briefly, about the proposed entrance turnaround area constructed prior to the plat being recorded, with possibly the option of some type of bond or letter of credit or something such as that could be done to enable the plat to be recorded with some time frame, you know, let's say springtime, when construction of a road or something such as that may be more, be easier anyway, and be able to have a more quality product, I would say.
Ben, would you be okay with that, or Matt?
I think it's a commission decision, because
Yeah, I mean,
we
it's,
say we only bond like final surface or sidewalks and things like that, so.
do you know what the rough estimate of that
No,
entrance would
and
cost?
before that would have to come in, I'm sure that, you know, typically it's, you know, probably 125%
I
of
think it is
cost.
125%.
And so, you know, and I think that would be, you know, whatever the estimate comes with, either it's engineer's estimate on our behalf or something that the county comes up with. I think that, you know, we could work with something such as that.
I know with the weather, and it is getting ready to snow, I think, any day now. You know, it would be kind of crazy to make them put in a road today or tomorrow or next 30 days before recording the plat. So it would make sense for them to bond 125%. Joe, we could probably let you and not make them come back, make the decision if they bring an expense of, here's a couple proposals, it's gonna cost, somewhere between 20, I don't think it, 20,000 or something. Be 125% would be, whatever that is, 24,000? Okay, I think it'll be okay. And commission okay with that?
Yep.
All right. Any other questions for Mr. Stevens? Thank you, sir. Any questions for Mr. Stevens? Otherwise, I'll entertain a vote. Thank you, Mr. Stevens.
I have a question for Mr. Stevens or Mr. Humphrey. Matt brought up that one slide with possibility of multiple residences left on that 9-acre tract. Could you please address that?
That's not something that I guess I'm aware of. I've been in Mr. Humphrey's house.
We'll bring Mr. Humphreys up. We'll pick on him a little bit. Oh, there you go. Swear him in, Mr. Perkins.
Do you swear affirm the statement you're about to make to be the truth to the best of your information and belief?
I do.
Thank you.
I've been on that farm since 1957. Even if there's a 9.5 acre tract left, that little house out back is like a guest house. It's been there for 42 years. And that's all I can say. It's been there for a long time. On that last case we had where there's less than 5 acres per house, I don't know if that was a requirement 40 years ago, but I don't know if grandfathered in means anything, but that's like the guest house. When we fixed the house up front, the front part of that, the big house was built in 1797. And when we tore off the back of that house and rebuilt it 38 years ago, my parents moved into the little house while all they had was a living room in the big house, basically. And there's 2 septic systems out there. There's 2 of everything out there. As a matter of fact, the water system wasn't put into that property until they built the little guest house out back. And the water comes from the road out to that little house and then comes forward to the big house. I mean, that property's been in my family for almost 70 years. So all I can say is, I'm not gonna tear down that little house.
So, Mr. Humphreys, how many structures or houses are there on the remaining
Well,
9.5
I
acres?
call it the big house and the
Right, and so there's 2.
Yeah.
Charlie, to Mr. Humphrey's point, if they've been there for 40-something years, would,
And as such, they could stay there. The
Right.
problem is created when you try to cut away from the existing property. You're actually reducing it, making the intense use even greater. A non-conforming use can stay, but you can't make it worse. And by taking some of it, now you go from whatever it was, 15 or 16 acres down to 9, and so now you got 2 houses on 9 acres where before you had 2 on 16 or whatever it was.
Right.
Well, actually, you've now created a violation. Well, we certainly can't do that. So that's why Matt was saying,
now it's interesting, I got a question, and I'm not an architect or you've got an engineer, you got 9.5 acres, and the other one's 6.4.
Well, I
Could you
think-
not have done 5.9 and then left that one
If I have to, we'll just
10?
move the border on the
Yeah.
new Plat 8. We'll move it.
But then that also may cause some issues with that entrance. I was looking at.
No, it won't change the entrance because we've already agreed, the new purchaser of Plat 8, if it happens, has agreed we're gonna share the costs of making that hammerhead, the new entrance.
Okay.
And his driveway will come off that hammerhead towards the west. So whatever we have to do to make that work, that's
You
not a
might
problem.
reduce that 1 to 5.9
But yeah,
acres.
and leave the other one at 10 plus, and because there's not sufficient separation, but that's non-conforming. That's been there for 70 years.
So it wouldn't really matter whether it's 9.5 or 10.
No, I'm saying that would solve that problem because there would be 2 houses on a 10-acre tract, which is what we require.
Right.
The separation between them was pre-existing. That's non-conforming, so that's not a violation. We're not creating a violation. So I think you're right. I think you nailed it. Make the other one 5
5.9 instead of 6.4, and then keep the other one
And
10.
then I think we can do that.
But then he'd have to go to back to drawing board, because then we're gonna need a new, plat and a new,
You could do like the lady in court a few years ago, she just drew her own lines and
Yeah.
handed it to the judge. He didn't take it, of course, but.
without continuing this, could we just make it well, go ahead, Joe.
Approve it preliminarily, and as long as the lot line change.
Shift.
Yeah.
Oh, well-
just,
You'd be okay with a 5.9 and a 10
Well,
acre?
let staff approve that when he brings it back in.
If I may say this, the roads have all been put in. The fences have all been put in. They are where they are. And whether we move the drawing, it's just like the drawing we had last month. We included the easement into Tract 8's property. This month, we put the easement back into my property. It's just a matter of where you draw the pencil line is what it boils down to. It's not gonna
Right.
change anything. So all I'm saying is if you can allow the extenuating circumstance and the variance of a half an acre on the original property, it's not gonna change anything.
The difficulty, and I understand what you're saying, and pencil line, that's probably as accurate as anything we've said tonight. The difficulty is, we absolutely have no legal authority to create a substandard situation.
Okay.
So we're great, even if you've got to change the line and add easements to it, so you leave the fences where they are. But we can't create an illegal situation.
Okay.
So you could ultimately leave the fence where it's at, as long as the person you're selling it to is
They
gonna
know.
be okay with it?
And get it in writing, please get it in
Yeah,
writing.
there you go, thank you. Thank you, Charlie.
They already understand.
Well, I know,
The
but people's understanding, boy, gets warped. Please get it in writing.
The second and third generation.
We'll start, yeah.
Sometimes the first generation.
With that being said, any questions for Mr. Humphreys or Mr. Stevens?
The thing I will say, I have brought Scott County 5 new $300,000 houses and the water bills and the electric service. So Scott County should be happy with the new property.
And I guarantee you, they appreciate it. Now all they want is change those lines.
At least there's none of Scott County here for this one. that
Thank
I'm
you,
happy
sir.
with.
All right, I'll entertain a motion.
I'll make a motion for approval.
All right,
with
we got a
the,
motion by Mrs. Singer with the
change to
nine,
the- yes.
nine conditions of approval?
And then,
And
they
the
can bring-
adjustment to
And the adjustment to
Yeah,
the,
which they can bring back to staff, don't have to come
Yes.
back here.
yeah, please, Mr. Stevens.
We'd also, on item number 6, if we were going to talk about the possibility of do some type of,
Oh, the bonding,
Oh,
yeah,
yes.
thank you for bringing that up, and probably add that as condition 10, to bond 125% of the cost, so they can do that road.
The entrance.
The entrance in the spring, not, within the next 30 days. So it'd be condition 10, you think, Charlie, would add that on?
Yes, sir.
To bond 125% of the cost, and you can bring that cost or proposal to,
same as, I think might be a modification to item 6,
okay.
instead of a new item.
Transfer about should be constructed, yeah, we could probably change that,
yes.
and maybe do a comma and
Yes.
bonding of 125% for the cost of the entrance. We'll do it that way, so I need a motion, I had a motion by Mrs. Singer,
Yes.
I'll second.
I got a second by Dan,
LOC,
or, yeah, letter credit's fine.
I gotta get, we really don't want it.
Okay, it is it's not, okay, so we can just do a vote. All in favor, say aye. Aye. Anybody opposed? Motion passes. Thank you, you can go up here and sign with, Mr. Perkins. Next on the agenda is, looks like last one, ZMA 2021-46, 1106 Horseshoe Drive zoning map amendment to change the zoning district from R2 to B2 located at 1106 Horseshoe Drive. This is a public hearing, so we'll open it up as a public hearing, and I like to see the large crowd we have.
Knocking down the door.
Yes.
Just note that I have to.
And for the record, and I didn't mention this earlier, Stephen Smith is absent, and Mrs. Singer is now leaving us.
Yes.
Have a good night.
This one seems pretty straightforward. I think the gentleman can handle that one.
I think we can do it without the hearing. Go ahead, Joe.
All right.
All yours.
This is a zone change from R2 to B2 Highway Commercial on Highway 460 across from Texas Roadhouse. It's a remnant of a larger parcel. It's .716 acres in size. And my presentation is a little bit different than my staff report because when I was putting together the PowerPoint, I realized I made a mistake in my staff report. In the future land use map for this entire property is residential. It's not split. The zoning is split. So I'll get into that in a minute. But so this property is off Horseshoe Drive. And it's the area of this lot, and it is a larger lot, 4.84 acres, that hasn't been split by subdivision. So this is kind of a remnant that's zoned differently than the rest of the lot. And it's the piece with the house on it. At one time it was lived in, but I think it's been used commercial for a long time at this point. And it's currently being used as part of the carriage house business. I can get this to work. This is the parcel. We asked on the concept plan, because we asked for a concept plan with any zone change. They've showed a concept plan just for this remnant parcel, and they're just showing the potential use of the continued use for the continued use of the residence for commercial uses and adding a small parking area in front on the concept plan. I think eventually this property will be developed in its entirety, probably be subdivided and split differently if you approve the zone change. So the zoning on the property and really on the all the way down from the bypass all the way down to the creek, it's mostly commercial on that side, other than the residences on Horseshoe Drive. So there's a bank, old bank on the corner. There's a triangular portion of on the 460 side of Horseshoe that's commercial, and then all the way down to the creek is zoned right now B2 highway commercial. The future land use map itself, and this goes back, this kind of harkens to the Oxford zone future land use designation. So future land use map is drafted not based on parcel boundaries. Typically, it's more at a higher level. We look at it, and a lot of times when it's created, it kind of designates areas kind of when it's done at a scale. It can designate it, like in Oxford, for instance, a large area of Oxford commercial, where really in practice we probably don't want all that to be rezoned commercial. And it's kind of like in this area, most of it's zoned and used commercial already, but you know, it picked up the neighborhood behind it and just kind of carried that over on a future land use map, probably from the 2000s. And when we update that every 5 years, typically we target, you know, we look at targeted areas where we think a lot of development is occurring, and we kind of look at those specifically. And a lot of these old future land use maps are carried over from the previous. So everything's left the same, but we look targeted at different areas, and those might be changed. I think Oxford, and I think probably this area will have to be looked at more closely in the next update. And there's a few other areas that I think were kind of blanketed with the residential or commercial that may not be, when you look at it in more detail, may not be appropriate. So we rely on not just the future land use, but the goals and objectives of the plan as well. They kind of go together. So this area is actually planned residential on the future land use map, or designated residential. Our goals and objectives, well, first, to get back to KRS 100, we always look at these standards when approving or recommending approval on a zone change. So is it in conformance with the comprehensive plan? Not just the future land use map, but the goals and objectives of the plan. And if it's not in conformance with that, if we have a finding it's not in conformance with that, is it zoned inappropriately? So for some reason, is it zoned inappropriately and there's a more appropriate zone? Or B, have there been changes of a physical, economic, social nature that would justify the change? And those changes shouldn't have been considered when we last updated it. So in my staff report, I identified one and and A, I think, as being the justification for the rezoning. I think the main justification for the rezoning is it's part of a larger tract that's already zoned commercial, and it's on a major road in an area that's largely commercially developed. I think it would make sense to consistently zone the whole parcel as it exists. So I think our goals and objectives for redevelopment and I've identified CF 1.1, 1.2, and 1.3, and those have to do with kind of redeveloping areas where there's existing commercial development, where you have access to major thoroughfares, where there's higher intensity uses in place. And then just the idea that we want it developed commercially where within the urban service boundary where there's city services and properties that have been annexed or can be annexed. So I think generally, although the future land use map doesn't support or calls this area residential, I think it is a commercial area. It's been developed commercially. So I think overall, if you look at the goals and objectives as well, I think they can support commercial rezoning of the property. And I think you can point to, it being zoned inappropriately, and there's a more appropriate zone for it since it is part of a large parcel, 4.84 acre parcel that has commercial use on it, and the house on the lot is being used commercially presently. So all that being said, we do think there are findings to support a rezoning to commercial, and primarily I'm pointing to item A in KRS 102.13, and that is the current property is zoned inappropriately, and there would be a more appropriate zone for it that could be supported by the comprehensive plan. With that being said, we are recommending 5 conditions. I believe the house on the lot is on septic. We think if it is redeveloped, it should be on sewer. So we are making the recommendation that any redevelopment, construction, or placement of new buildings on the project site shall require connection to public sewer. I added number 3, and this carried over from Matt's previous recommendation on the Oxford Road rezoning, and we kind of addressed this, that this is really a development plan issue, the lighting, but we kind of like, whenever you have commercial next to residential, we like to point out that you need to plan it, for appropriate lighting so it doesn't impact the neighborhood behind. So I did throw this in there. I mean, I don't think it hurts anything, but it's really not a zone change specific condition. And then number 5, there are sheds stored on the property now. There is a conditional use permit for them for the portion of the lot that's further down towards the creek, but we are requesting that they amend that conditional use permit if they want to keep those sheds on this piece, because technically you cannot, outdoor storage of that kind is not allowed on a residential lot, but if it is approved and rezoned to commercial, you could use it that way if you get a conditional use permit, so they'll have to update their conditional use permit to include this area of the lot.
Okay. Before I even open it for questions, have we had any neighbors call? Because this is a public hearing, and there's nobody here.
Yeah, I haven't had any.
Okay.
Nope.
And
we
were
did
the
got-
appropriate mailings done? Do we know, or is that a question for the
Yeah,
applicant?
you can ask him, but I do have record of the mailing. I
Okay.
did get the notification.
Perfect, thank you. Any questions for Joe?
Hey, Joe, just for the, for the record, it's got, on the front page, it's got access Horseshoe Drive and Frankfurt Pike. That should be Paris Pike there.
I caught that too.
Did I say Frankfurt?
But that's what it says,
Sorry.
Frankfurt.
That's stretching it
Part of the
out.
road.
So it's Paris Pike, not
I mean,
Frankfurt
just
Road.
depends on which direction you're facing.
Yeah, exactly.
You know?
All right. If there's no other questions, we'll bring up the applicant. Thank you, Joe. Mr. Cato?
Don't y'all want me to talk fast, huh?
Please.
You're not done already?
Yeah, you can take your time.
I won't do any of my magic tricks. I had a whole bunch of stuff planned, but I'll leave them out for this time. So I'm here with Doug Smith, the applicant, and the owner of the property sitting next to him, Karen Tingle-Same. She runs the carriage house. That's the part of the bigger lot we're talking about. I think everybody knows. Just so you can see it, these 4 parcels in yellow, that's like the outline of what the legal description is on this property. It's kind of divided up into these 4 parcels, but it's never been technically subdivided, so this is all kind of one big tract we're talking about. Like the one I spoke to you about earlier tonight, we're not proposing any development. There's no changes planned here at this time. It's kind of a cleanup to get the zoning all consistent on this parcel. My understanding is that Ms. Ames thought it was already all B2 until not that long ago and realized there was this issue. So this is kind of to clean that up. All right, you all know where this property is. I'm sure you've all driven by it a million times. I won't waste a bunch of time on that. There it is. So just one thing I want to point out, this is a true concept plan. So we're not planning on building this parking lot. We were asked to show the buffers, setbacks, how access would work, to add that to the concept plan we did originally. So we're not planning on building that. It's just to show that it would be feasible if this lot were to develop kind of by itself without being subdivided out. There is a way to make it work, but we're not planning on doing that right now. So that's, just so you know, that's why you're seeing what you're seeing on the concept plan. Legal change, Joe went over that. I won't waste your time. Existing center of activity, like Mr. Kane said, we're not expanding anything. We're not requiring any new services to be provided anywhere. We're not going out into the country. It's already in a very heavily traveled, pretty dense area. We agree with the staff report and what Mr. Kane said a few minutes ago. We think the comprehensive plan overall supports this, as well as his comments about the future land use map. It's urban residential is technically what it's recommended for, which can include small businesses that don't impact the neighborhood character. That's what we're talking about here, at least as far as this parcel is concerned.
And for the record, this will make the complete parcel B2.
Yes. Yes. We agree with the conditions of approval. I have a similar comment. I had a similar comment to make as what I made earlier, but I think after what Mr. Kane said, explaining what the light condition is, and that's really more of an appropriate for development plan stage, that we're all on the same page. I don't think I have anything to add to that. I think everybody knows that's really going to be taken up when the redevelopment's done, if and when that happens. So we don't have to go through that. So we just ask that you would approve it with the conditions that staff recommended.
Thank you, Mr. Cato. Any questions for Attorney Cato? With that being said, is anybody here to speak against or for the application? If not, then we'll close the public hearing. And then entertain a motion. Or unless there's more discussion. Mary's here, not here, so that'll lessen the discussion.
It cost me $50.
Don't tell her I said it. Don't tell her I said that.
I make a motion, we accept,
So I've got a motion by
1221-46.
Dan Smith.
With the amendments, or with the recommendations made by the board.
Do I have a second?
Second.
I got a second by Mr. Mifflin. Because it is a zone change, we'll do a roll call. Again, for the record, Mary Singer's absent. Rhett Shirley,
Yes.
Mr. Mifflin,
Yes.
Mr. Vest,
Yes.
Mr. Stone,
Yes.
Mr. Garrett,
Yes.
Mr. Dan Smith,
Yes.
and the chair votes yes, approved. Thank you. And then, I think that's all we have. Looks like, next thing on the agenda is a short-term rental ordinance that's continued next month, so we won't even talk about that.
We just need a motion and a vote to approve the meeting.
Oh, yes, so I
dates
need a
and
motion to approve the meetings for next year, 2022.
Yeah.
So made.
So I got a motion by Mr. Stone,
Second.
second by Mr. Garrett. Was that you?
Yeah.
All in favor, say aye.
Aye.
All right, motion carries. I need a motion to adjourn.
So moved.
All right, second.
Second.
Y'all gotta put up
Meeting
with us
adjourned.
a few more months.
Not too bad.
We'll let y'all, you be careful.